I've already had my tacos this morning. A little chorizo and egg. Huevos and chorizo.
Good.
Good.
Did Rose make them?
Of course not. So, no.
Okay. You might be listening there. Be careful. That's the reason I threw that out there.
No, it was like, of course not. Just like, of course not. So, bad.
I took a picture of your face when you said it.
Yeah, did you get that? You ready to have him say it again?
No, no.
All right. I've got 9:01. You guys ready to start?
Yes, sir.
Let's rock and roll.
All right, let's do it. Good morning, everyone. The meeting is called to order. Mr. Trobman. There you are. Has anybody signed up for public comment?
Good morning, Commissioners. No, we have no public comment this morning.
Thank you so much. Good morning, Ms. Miller.
Good morning, sir.
Hey, we've got 2 cases to reconsider under agenda item 3. Is that correct?
Yes, sir, that is correct. Commission Appeals is requesting permission to resubmit case number TD-19-059-049 on a future docket. This case appeared on docket 48, voted on December 1st, 2020. The commissioners voted to affirm in part and grant a rehearing under Rule 815.113 on the LLC liability issue. However, testimony on that issue has already been taken. So we're requesting to resubmit the case based on the existing record without conducting an additional hearing. Commissioner Demerson?
Agree?
I'm sorry, Commissioner Alvarez?
I agree.
And Mr. Chairman?
I agree.
The second case, Commission Appeals is requesting a letter of continuing jurisdiction in case number TD-20-077-0620. On docket 47, on November 24th, 2020, the Commission voted in part that the employer became a liable employer under the Texas Unemployment Compensation Act, Labor Commissioner dissenting. The decision was mailed on November 24th, 2020, with an appeal deadline of December 24th, 2020. No appeal has been filed. The decision contains a clerical error regarding the effective date of liability. Therefore, we are requesting a letter of continuing jurisdiction so that the clerical error may be corrected. Commissioner Demerson?
I agree.
Commissioner Alvarez?
I agree as well.
Mr. Chairman?
Agree.
Thank you very much.
Okay, let's move the tax liability cases under agenda item 4. I think we have 1 tax case on docket 50.
Yes, sir. And it is case TD-20-012-0120. Commissioner Demerson?
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
And Mr. Chairman?
Agree with staff recommendation.
Thank you.
Okay. Let's move to agenda item 5. We have no fair housing cases to consider today.
That is correct.
Okay, and so we'll move to agenda item 6. We have 1 wage claim case pulled for additional discussion on docket 50.
Yes, sir. It's case number 20-050518-2. Commissioner Alvarez?
The decision is not supportable. I agree that the claimant was an employee. The employer alleges that the claimant was notified that his wages were changed in a meeting. The employer and the claimant have provided differing descriptions of that meeting. Another employee was present for this meeting. This employee, when speaking to the investigator, denied that the employer said that he was ending the hourly wage. The case should be reheard for the testimony of the only other person present at the meeting. I ask for rehearing.
The AT decision is supportable. We agree that the claimant worked as an employee of the company. Regarding the wage issue, the employer presented clear and convincing testimony that due to problems with the claimant's productivity, the claimant's pay agreement was changed from 60% commission plus $9 per hour to 66% commission without an hourly rate. In accordance with that agreement from the point until its separation, with the exception of 14.5 hours that the claimant worked before being informed of the new pay agreement. Accordingly, we should affirm the AT decision. The claimant was an employee, $130.50 owed.
Rehear.
We will rehear the case. And that is the only pulled case under this agenda item. I did send you the wage claim short form dissent list just a moment ago.
I'll move we accept staff recommendations on the remaining wage claim cases on docket 50.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for docket 50.
I concur with the chairman's motion, except for the cases on which I'm dissenting, as reflected in the wage claim short form dissent list for docket 50.
The motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 50. Please proceed when you are ready.
Case number 2467856, Commissioner Demerson.
The AT decision should be reversed. The parties agree that the claimant was on deferred adjudication for a criminal case when he was hired to work for the employer. The parties also agree that the claimant was placed under community supervision. The dispute lies in whether the claimant should have notified the employer of condition number of his community supervision, namely that tracking software was required on any computer he used with internet access. The claimant does not deny this condition exists. However, he argues that it only applied to his personal computer. This is neither credible nor persuasive. The Harris County Online Criminal Records database contains the claimant's agreed conditions of community supervision, which was signed by the claimant, a judge, and included the claimant's guilty plea. The language of condition number 29 states that the claimant was not to have access to the internet through any manner or method unless it is equipped with the approved tracking software for any reason, unless specifically ordered by the court. Clearly, the broad language of this condition required the claimant to have tracking software on any computer he used with the internet, not just his own, and we should take administrative notice of these records. Thus, the claimant should have known to report this condition to the employer upon his hire, because the computer he used at work had internet access. When the claimant failed to apprise the employer of his internet restrictions, he violated the employer's ethics policy and mismanaged his position of employment. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
A decision should be affirmed. As part of the claimant's deferred adjudication, the claimant was restricted in his use of his personal computer. The claimant's probation officer was aware that the claimant used a computer at work and had approved the claimant's job. Therefore, the claimant's deferred adjudication was not workplace misconduct. Additionally, the claimant never acknowledged the employer's ethics policy, and the policy is too vague to form the basis of misconduct. Affirm the 18, no misconduct chargeback.
From the 18, no misconduct chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2474103, Commissioner Demerson.
The AT decision should be modified. The severance pay of 82 weeks received by the claimant does not meet any of the exceptions to disqualification under section 207.049B of the Act. In addition, there is no basis for concluding that the presence of a non-compete clause in the agreement converts this pay to non-disqualifying severance. Moreover, the AT decision should be modified to begin the disqualification effective November 17, 2019, the beginning date of the claim week in which the claimant received payment. We should modify the AT decision. The claimant received disqualifying severance pay from November 17, 2019 through October 31st, 2020. Recalculate overpayment and make the employer a party of interest.
The decision should be reversed. At the time that he signed the severance agreement, the claimant had potential age discrimination and FMLA claims against the employer. Additionally, the agreement the claimant signed prohibited him from working in his chosen profession for 2 years after the separation. Since the claimant had potential claims against the employer, and since the claimant gave up valuable rights under the agreement, the payment made to the claimant does not constitute disqualifying severance pay under section 207.049. Reverse the AT, no severance, disqualification, no overpayment.
Reverse the AT, no severance, disqualification, no overpayment. Employer is a party of interest.
Short form, Chair.
Yes, sir, Commissioner Demerson.
All right, thank you.
Case number 2480941, Commissioner Demerson.
The AT2 decision should be modified. Regarding timeliness of the claimant's appeal, the AT2 decision was issued to the claimant with an appeal deadline of April 8th, 2020. The claimant faxed her appeal on 9/9/2020, over 5 months late. The claimant did not explain why her appeal was late, nor did she allege that this information from a TWC representative or technical difficulties with the TWC system prevented her from filing a timely appeal. As such, her appeal is late, and we do not have jurisdiction to consider the underlying merits of this case. Accordingly, we should modify the AT decision, untimely claimant appeal, leave the underlying AT2 decision in full force and effect.
The claimant's commission appeal should be deemed timely because her appeal period fell within the time that TWC resources were difficult to access, which caused confusion and misinformation. The claimant failed to establish good cause for her non-appearance. However, she should be qualified for benefits. The record established at the first hearing shows that the claimant was instructed by the employer to leave the premises. The employer testified that they discharged the claimant, but they did not provide a reason for the discharge. As the employer initiated the separation without providing a reason, the claimant should be qualified for benefits. Deem the claimant's appeal timely, no good cause, no misconduct, chargeback void, adequate response.
Dismiss the commission appeal is late. The AT decision remains in full force and effect.
Commissioner Demerson, did your vote relate to the late CA or a late petition to reopen?
We were untimely claimant appeal. So we were dealing with untimely claimant appeal.
Late appeal to the commission, sir?
Yes.
Okay. Then we have a majority vote that there was a late appeal to the commission, and the most recent appeal tribunal decision remains in effect.
Yeah.
Commissioner Alvarez, any dissent?
Yes, short form dissent, Ms. Miller.
Yes, sir, I've got it.
Thank you.
Case number 2484175. Commissioner Demerson.
The AT decision should be affirmed. The claimant's testimony indicates that the final incident occurred when she wrecked a company vehicle. In testimony, the claimant admitted that she accidentally wrecked the vehicle. Since the AT was in the best position to weigh the evidence and gauge the credibility of the parties, and since the claimant's testimony is self-disqualifying, we should affirm the AT decision, misconduct, overpayment of $480.
The decision should be reversed. After a workplace injury, the claimant's hours were reduced until she completed separated, until she was completely separated. Following the rehearing, the employer has now twice failed to appear to present evidence of misconduct. As a greater weight of the available evidence indicates that the claimant was separated following her workplace injury, she should be qualified for benefits. Reverse the AT, no misconduct, no overpayment.
Reverse the AT, no misconduct, no overpayment.
Short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2487485. Commissioner Demerson.
The AT2 decision should be affirmed. The claimant filed an appeal to the AT1 decision 2 days late. The claimant did not provide any reason for his late appeal, and as such, there is no evidence that technical issues prevented the claimant from filing his appeal on time. Since the claimant failed to give testimony concerning the timeliness of his appeal, and since the determination were mailed to his correct address of record, the claimant's appeal is not timely, and we should affirm the AT2 decision. The claimant filed the late Rule 16 petition to reopen, leave the underlying AT1 decision in full force and effect.
As the claimant's appeal period fell within the time that TWC was experiencing issues, mailing decisions and receiving appeals due to the pandemic, we should deem the claimant's petition to reopen timely and remand.
Affirm the AT, untimely petition to reopen. The AT1 decision remains in full force and effect.
Short form dissent.
Thank you, sir. I have your short form dissent.
Case number 2581318. Commissioner Alvarez.
The AT decision should be modified. I agree that the claimant filed a valid claim. In the month before the claimant filed her claim, the employer reduced her hours of work to about 10 hours per week. After working these reduced hours for about 4 weeks, the claimant agreed to a temporary leave agreement in which she did not perform services for the employer, but was paid for about 5 hours per week. The claimant accepted the agreement and filed for unemployment benefits. The claimant did not voluntarily quit the job, Rather, she continued to be employed by the employer in a part-time capacity. The claimant's hours had already been substantially reduced to part-time work before the claimant accepted the temporary leave agreement, and the employment relationship continued as she was paid for 5 hours per week. The claimant filed her claim as a partially unemployed individual after the employer initiated a reduction in the claimant's hours, and she should be held not disqualified under Section 207.044 of the Act. Modify the AT, valid claim, no misconduct, chargeback.
The AT decision should be modified. I would agree that the claimant's separation was due to the disaster. Accordingly, we should modify the AT decision, no voluntary leaving, no chargeback, separation due to disaster, sever validity of claim issue.
Modify the AT, no voluntary leaving, no chargeback, disaster, sever validity of claim issue.
Ms. Miller, I would agree with the chairman and with Commissioner Demerson.
Thank you. We have a unanimous decision.
Case number 25820098, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant worked for the employer as a substitute paraprofessional. Employees working in the capacity of the claimant must log in to an online system to accept available assignments. After the claimant finished her last assignment, she failed to select any further assignments, even though unfilled substitute jobs were available for her to accept every day. Since continuing work was available for the claimant at the time she stopped selecting assignments, she quit without work-connected good cause, and the employer should not be billed. We should therefore reverse the AT decision, reimburse an employer, not billed.
The decision is supportable. The claimant worked for the employer on an as-needed basis by accepting available substituting jobs on the employer's system. The claimant worked one job for the employer and should be considered involuntarily separated for reasons other than misconduct and the conclusion of that assignment. As the claimant was separated for reasons other than misconduct, the employer's account should be billed. Affirm the AT, bill, reimburse an employer.
Reverse the AT, reimburse an employer, not bill.
Ms. Miller, short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2586141, Commissioner Alvarez.
The AT decision should be reversed. The claimant was accused of driving on the job in an unsafe manner. However, the claimant has consistently maintained that he did not drive in an unsafe manner. The employer presented only secondhand hearsay evidence of its allegations. The claimant's firsthand testimony denying wrongdoing outweighs the employer's hearsay evidence. The employer did not provide sufficient evidence to establish any misconduct by the claimant. Reverse the AT, no misconduct, chargeback, no overpayment.
The AT decision should be affirmed. Since the claimant provided inconsistent statements about his unsafe driving, his denials of wrongdoing are not credible. As company policy provided that the claimant could be discharged for safety violations without prior warnings, we should affirm the AT decision. Misconduct, no chargeback, overpayment of $4,168.
Reverse the AT, no misconduct, chargeback, no overpayment.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2588959, Commissioner Demerson.
The employer's motion for rehearing should be granted. The employer's new evidence consists of audio recordings that appear to reflect the incident that led to the claimant's separation from employment. Due to the profane language that was described in the audio recording, this new evidence could change the outcome of the case. A compelling reason for not having submitted it earlier, it appears to the employer's motion that it was not aware that the audio recording in question had been moved to a different server on the employer's system. Since one cannot know what one is not aware of, the employer's reason for not producing the cause even earlier should be viewed as compelling. Accordingly, we should grant the employer's motion for rehearing.
The motion for rehearing should be denied. In the employer's motion, they state their failure to provide the evidence earlier was due to internal errors. As the employer's failure to provide the evidence earlier was due to issues within their control, they have not provided a compelling reason the evidence was not offered earlier. Deny the motion for rehearing.
Deny the motion for rehearing.
Short form.
Thank you, Commissioner Demerson. I have your short form dissent. And before we proceed to the next case, I did just want to mention that when we get done with the last case, the 24th case, I would like to return to case number 3, which is the one with the late CA. I want to ensure that the votes are definite there. I just want to make sure everybody's on the same page and that the vote is clarified. So if you don't have any objections, once we get finished with the last case, I would like to return to case number 3, which is 2480941.
No objection.
Thank you, sir.
Case number 2591909, Commissioner Alvarez.
The decision is not supportable. The claimant was originally approved for PUA benefits because, as a single father, there was no one to care for his son when his son's school was closed on March 23rd of 2020. The claimant did not have any other alternatives. After exhausting emergency leave on April 6, 2020, the claimant was unable to return to work and separated from his employment. Although his son was able to return to school on August 18, 2020, the claimant was already separated from his employment as a direct result of the pandemic and unable to return to work. As such, the claimant should be eligible for PUA benefits. Reverse the AT PUA eligible.
This case should be resubmitted with the discussion of relevance of UIPL 16-20. The DOL guidance in attachment 1, section C1D on pages 11 and 12 indicates that someone in the claimant situation may be considered eligible for PUA benefits. I'd like to see a discussion of the relevance of that section of the UIPL before making a final decision on this appeal. So my vote is to resubmit this case on a further docket for that purpose.
All right, I concur with Commissioner Demerson. And then I'll also ask to hold this case as a companion with the claimant's regular claim case.
Yes, sir. We will resubmit on the future docket and present it as a companion to the regular UI case.
Case number 2594576, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant was offered work in the same capacity she had been working prior to being separated. Accordingly, the work offer was suitable. In addition, the claimant did not have good cause to reject the offer of suitable work. The claimant stated that she would have to interact directly with customers as part of her job. The claimant may have had completely reasonable concerns about being fearful of COVID-19, but those reasons are nonetheless personal, and fear of the virus by itself does not constitute a good cause reason for rejecting suitable work. We should therefore affirm the AT decision, suitable work disqualification, overpayment of $1,362.
The staff recommendation is appropriate. The claimant ceased working for the employer due to the pandemic. The employer contacted her a few weeks later asking if she wanted to return to work. The claimant's job required her to come into a direct contact with the employer's customers. Additionally, the claimant has provided that other employees became sick on the job. As such, the claimant had good cause to reject the offer of work. Reverse the AT, suitable work eligible, no overpayment.
Affirm the AT, suitable work disqualification beginning April 26, 2020, overpayment.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2602420, Commissioner Alvarez.
The decision is not supportable. The claimant called in sick with a fever of 102 degrees. Her supervisor instructed her to quarantine for 2 weeks. The claimant did as instructed and maintained contact with the employer during her quarantine. At the conclusion of her quarantine, the claimant returned to the employer and was notified she had been discharged. The claimant's supervisor further confirmed her discharge after speaking with HR. No evidence of misconduct has been presented in this case. Since the claimant stopped working when the employer required her to quarantine, it would be acceptable to protect the employer's account due to disaster. Reverse the AT, no misconduct, no chargeback, disaster, and sever valid claim issue.
The appeal tribunal decision should be modified. In summary, the employer's response to the notice of application for benefits states that the claimant went out on personal leave without requesting leave or providing a written resignation. The employer's response also stated that continuing work was available. Accordingly, since the claimant did not take adequate steps to protect her job, she quit without work-connected good cause. We should therefore modify the AT decision, voluntary leaving, no charge back, sever the validity of claim issue.
Reverse the AT, no misconduct, chargeback, sever validity of claim issue.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2606436, Commissioner Alvarez.
The decision is not supportable. The claimant has underlying medical condition which places her at a higher risk should she contact COVID-19. While the employer implemented COVID procedures, not everyone in the facility wears masks or wore masks. Further, the employer's clients were coming in and out of prison and did not always have proper PPE equipment. As such, the claimant had good cause to quit. Reverse the AT, no voluntary leaving disaster, and sever valid claim issue.
The appeal tribunal decision should be modified. The claimant quit her job out of fear that she might contract the COVID-19 virus. The claimant stated that the employer implemented COVID-19 pandemic safety and protection measures about 1 month before the claimant resigned. The claimant also stated that she did not seek medical advice before resigning from her position. As such, the claimant's quitting was without work-connected good cause. She therefore modify the AT decision, voluntary leaving, sever the validity of claim issue.
Modify the AT, voluntary leaving, sever validity of claim issue.
Mr. Chairman, can you repeat your motion? I think it garbled a little bit.
Modify the AT, voluntary leaving, sever validity of claim issue.
Miller, short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2607369, Commissioner Alvarez.
The AT decision should be affirmed. The employer reduced the claimant's work hours due to the pandemic, and the claimant filed her claim for benefits as a result. At the time that she filed her claim, the claimant worked part-time hours and earned less than 125% of her weekly benefit amount. She therefore filed a valid claim as an unemployed individual. The employer contended that the claimant also was absent from work for personal reasons, and part of the reduction in hours was at the claimant's initiation. However, the employer acknowledged that most of the reduction in hours occurred because the clinic hours had been reduced. The employer did not provide any specific information as to which days the claimant was absent or how often the claimant was absent. The employer has failed to establish by credible evidence that the reduction in hours was at the claimant's initiation. The claimant should be held qualified because her hours were reduced at the employer's initiation. Finally, since her employment has not been completely severed, the claimant has received no payments that could be considered severance. Affirm the AT valid claim, no misconduct, bill the reimbursing employer, severance pay eligible.
The appeal tribunal decision should be modified. I agree that the claimant filed a valid claim and did not receive any additional wages or severance payments. As to the job separation, the employer stated that when the claimant filed her claim, her hours may have been reduced slightly. However, the employer also stated that the claimant requested several days off throughout the last few months, which may also explain why there was a reduction in her hours. Accordingly, a reasonable conclusion can be drawn that the claimant actively contributed to reducing her own hours and should therefore be responsible for subsequent periods of unemployment. We should modify the AT decision, valid claim, voluntary leaving, reimbursing employer not billed, no severance disqualification.
Modify the AT, valid claim, no misconduct, bill reimbursing employer, no severance disqualification.
A short form dissent.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2607401, Commissioner Alvarez.
The decision is not supportable. The employer's instructions were that the claimant should not see any patients until after he received a negative test result. The claimant has provided documentation showing he received a negative test result on the morning of July 1st, 2020, prior to paying a social call to a patient. The claimant complied with the employer's instructions. The claimant's actions did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The preponderance of the evidence in this case indicates that the claimant did not adhere to the employer's reasonable instructions relating to the pandemic. As such, and in light of the high-risk population that the employer serves, the claimant's actions constituted misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2609312, Commissioner Alvarez.
The AT decision should be reversed on the separation. The claimant quit the job to avoid risking her daughter's exposure to COVID-19. Her daughter has a congenital heart condition and is extremely vulnerable to severe illness from COVID-19 because of her health condition. The claimant was advised by her daughter's doctor to minimize her daughter's exposure to the disease. The claimant quit due to a medically verified illness of her minor child and should not be disqualified. Modify the AT, no voluntary leaving due to MVI, void chargeback.
We should affirm the appeal tribunal decision. I do not dispute that the claimant had a compelling reason for wanting to minimize her exposure to COVID-19. However, she quit without clearly communicating her concerns to the employer and without allowing the employer an opportunity to address these concerns. As such, the claimant quit without good cause connected with the work. We should affirm the AT decision, voluntary leaving, void chargeback.
Modify the AT, no voluntary leaving, disaster, void chargeback.
And with short form dissent, Chair. In addition, based on the claimant's testimony and documentary evidence, we should send a memo to UIO and CS to investigate the claimant's availability for work.
Commissioner Demerson, I have your short form dissent. We will send the memo. Commissioner Alvarez and Mr. Chairman, we have a majority vote that the claimant should be granted benefits. The rationale is different, however. Mr. Chairman, you voted disaster, and Commissioner Alvarez, you voted MVI. We need to select one rationale so we'll know how to draft the decision.
Ms. Miller, I would agree with the chairman's disaster.
Thank you.
Case number 2610920, Commissioner Alvarez.
The decision should be reversed. The claimant was offered work as a massage therapist, but the employer was not requiring clients to wear masks. The employer's failure to follow basic safety measures when the claimant would be in a small room with a client in close contact for over an hour rendered the work unsuitable. The fact that the claimant has been providing private massages for clients who wear masks demonstrates that he is willing to work when proper safety measures are taken. Reverse the AT, no offer of suitable work.
We should affirm the appeal tribunal decision. The claimant received an offer of work from the employer with whom he had worked for more than 4 years. Based on this previous employment, the offer of work was suitable on its face, but the claimant rejected it, citing fear of COVID-19. However, the claimant does not meet any of the COVID-related exceptions provided in TWC guidance for refusing an offer of work. Accordingly, we should affirm the AT decision. The claimant rejected an offer of suitable work.
Affirm the AT, suitable work, disqualification.
Short form. No, we're okay with that one.
All right.
Short form.
Mr. Chairman, did you say there was or was not a disqualification?
Suitable work, disqualification.
So there is a disqualification. And Commissioner Alvarez, did you have a dissent?
Yes, I will short form dissent on this case.
Thank you, sir.
Case number 2615109, Commissioner Alvarez.
Yes, ma'am. The AT decision on the separation should be reversed. The claimant was advised by his doctor to stop working on the night shift due to his health condition. The claimant notified his supervisor of his doctor's advice, but the supervisor did not grant the claimant's request to work on the day shift. The claimant quit the job when advised by his doctor to stop working on the night shift, but was not allowed to do so by the employer. He quit due to a medically verified health condition and should not be disqualified. Modify the AT, no voluntary leaving, no chargeback due to MBI.
Because the claimant's doctor did not instruct him to quit, but rather advised the claimant to try to find a day shift position in addition to improving his sleep and his diet, we should affirm the AT decision, voluntary leave, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2634050, Commissioner Demerson.
We should reverse the appeal tribunal decision. While it's true that the claimant's client went into the hospital, thereby ending the claimant's assignment, this did not necessarily trigger a job separation. We're all familiar with home health care precedent, which held that an employment relationship such as this one continues until one party clearly notifies the other party that the employment relationship is ended, even if there is some passage of time during which the employee performs no services or earns no wages. The president recognizes that in the home health industry, new assignments may not be available immediately. Such is the nature of the industry. Here, the claimant's assignment ended, and when she was not offered a new assignment on that same day, she immediately to look for other work. By notifying the employer that she was quitting to seek other work, the claimant severed the employment relationship. By quitting to look for another job, the claimant quit without good cause connected with the work. Accordingly, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The claimant's qualification should be affirmed. The claimant stopped working when her client was hospitalized. She inquired about other work with her supervisor, but she was not offered further work. She therefore was involuntarily separated for reasons other than misconduct connected with the work. Modify the AT, no misconduct, chargeback. I would also agree to a rehear in this case since the claimant was ill at the AT hearing. The hearing officer did not offer to postpone the hearing even though the claimant could not personally testify due to her illness. Rehear the case.
Modify the AT, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Demerson.
Thank you.
Case number 2640087, Commissioner Alvarez.
The decision should be reversed. The claimant quit because he was concerned about COVID. He lives with his at-risk mother and his pregnant wife. The employer testified that it was following CDC guidelines, such as requiring masks, but the claimant worked at a client site, not an employer facility. The employer admitted in testimony that he had no communication with the client about COVID cases in the facility. The claimant had heard from the family of residents that there had been COVID cases and deaths in the facility. The employer's failure to communicate with its client and contact trace to determine if employees had been exposed to COVID-19 created a dangerous work environment for the claimant. The claimant established good cause for quitting. Reverse AT, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. The claimant quit out of fear of contracting COVID-19. However, the employer was following the recommended health and safety guidelines. In addition, the claimant quit effective immediately and without first providing the employer an adequate opportunity to address any of his concerns. Thus, the claimant quit without good cause connected with the work, and we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent?
Yes, sir, Commissioner Alvarez.
Case number 2640244, Commissioner Alvarez.
We should deem the claimant's appeal timely. The claimant attempted to contact TWC through phone calls and emails numerous times for help with his appeal. He was finally able to complete the appeal online with the help of his son. However, the appeal was submitted 2 minutes after the appeal deadline because of issues the claimant experienced with TWC online portal. Under these circumstances, we should deem the claimant's appeal timely. Timely appeal and resubmit for merits.
We should affirm the appeal tribunal decision. TWC records indicate that the claimant received and opened the determination sent to him by electronic correspondence as per the claimant's election. The claimant testified that he did not notice the appeal deadline. Further, he provided no testimony regarding filing any earlier appeals. The determination is not an exception to the timeliness rules. The claimant also argues that his appeal was filed only 2 minutes after the deadline and that it should not be dismissed for a simple technicality. We should note that in the past, the commission dismissed an employer's appeal as late. The appeal was filed 30 seconds late. The claimant further submits evidence of an email reportedly sent to TWC during the appeal period. However, email in TWC is not considered an acceptable method for appealing. Acceptable methods are detailed on the determination the claimant received. Thus, because the claimant received the determination timely, has not met any of the timeliness exceptions, has not provided any corroborating evidence of having filed an earlier appeal, and there's no good cause exception to the timeliness rules, the claimant's appeal is late, and we are without jurisdiction to consider the underlying merits. We should affirm the AT decision. The claimant filed late appeal, misconduct, no chargeback.
Reverse the AT, timely claimant appeal, resubmit.
We will resubmit the case.
Case number 2653465, Commissioner Demerson.
We should modify the appeal tribunal decision. The job separation was initiated by the employer when there was no further work available to the claimant in his usual position due to lack of work caused by the COVID-19 natural disaster. The employer later offered the claimant a driving job, which the claimant refused. However, because the job separation had already occurred, the subsequent job offer is not relevant. The employer should not be penalized by trying to provide productive work to the claimant during the pandemic. Therefore, because the claimant was laid off due to lack of work resulting from the COVID-19 natural disaster, the claimant should be qualified for benefits and the employer's account should be protected from charge. We should modify the AT decision, no misconduct, no chargeback, disaster, void the timeliness of protest issue.
The AT decision should be modified. The claimant worked for the employer as a mechanic assistant, earning $19 per hour. He was offered a truck driver position, earning a percentage of the load and working substantially more hours. When the claimant declined that position, he was only offered a general laborer position, earning $12 per hour. The claimant had good cause connected with the work to resign rather than accept either of the positions, both of which constituted a material change in his hiring agreement. Modify the AT, void timeliness of protest ruling, no voluntary leaving, chargeback. If my fellow commissioners do not agree that there is sufficient evidence to establish that the claimant had good cause connected with the work to leave the job, I would also agree to rehear the case to further develop the record as the positions offered to the claimant, along with the rate of pay, hours of work, and working conditions of those positions.
Ms. Miller, can you read back to me Commissioner Demerson's vote?
Commissioner Demerson voted that there was no disqualification and no charge under disaster.
Did he also void the timeliness of protest ruling?
Yes, sir, he did.
I concur with Commissioner Demerson.
Thank you.
Ms. Miller, I will agree with the commissioner's decision on this case.
Thank you. We have a unanimous decision.
Case number 2667240, Commissioner Alvarez.
The decision should be modified. No voluntary leaving, no chargeback due to disaster. The claimant's wife has a medical issue and was on medication that affected her immune system. This put her at a higher risk for COVID-19. Her physician recommended that the claimant take time off from work until she could be tapered off the medication. The claimant followed this recommendation and with the permission from the employer, took unpaid leave off and then returned to work when cleared to do so. Therefore, as the claimant separation was caused by COVID-19, the claimant should be qualified for benefits and the employer's account protected from charge. Modify the AT, no voluntary leaving, no chargeback due to disaster.
I agree with that. We should modify the appeal tribunal decision, no voluntary leaving, no chargeback, separation caused by disaster. In addition, based on the claimant's testimony, we should send a memo to UIO and CS to investigate whether the claimant was available for work during the weeks in question.
I concur with Commissioner Alvarez.
Thank you. We have a unanimous decision, and Commissioner Demerson, we will send that memo.
Thank you.
Case number 2670260, Commissioner Alvarez.
The decision should be reversed. The claimant started a lawn care and housekeeping business and had 3 clients signed up for services. The clients canceled due to the COVID-19 pandemic. Because the claimant was scheduled to commerce employment and was unable to begin work as a direct result of the pandemic, the claimant is eligible for PUA benefits. Reverse AAT, PUA eligible, no overpayment.
Just like in appeal number 2591909 on this docket, I'm not satisfied that the AT decision or the staff recommendation have sufficiently considered the DOL guidance in UIPL 16-20 dealing with the PUA program. It's not clear to me that PUA is meant to be unavailable to individuals who, at the time that the pandemic hit, were attempting to start their business and service clients, but whose clients canceled because of fears of COVID-19. UIPL 16-20 and other relevant DOL guidance on the PUA may contain some definitive statements one way or the other. But since the staff recommendation makes no mention of that resource, I'd like to see this case resubmitted with a discussion of those issues before we make a final decision on this case.
I concur with Commissioner Demerson.
Thank you. We will resubmit the case. And returning to the third case, to clarify that vote, that is case number 2480941. Commissioner Demerson, you pulled this case. Could you please clarify your vote?
1 second, Sherry. Let me clear something.
Ms. Miller, while we're waiting for Commissioner Demerson, I'd also like some clarification on another case, if that's okay.
Certainly.
I have a question about one as well.
Very well.
Might be the same one, Chairman.
It's poll number 12 is the one I'm concerned about.
Last two numbers?
2602420.
That's correct. That's mine. The one I have a question on.
Okay.
Sherry, I'm going to go ahead and let me reread this into the record, okay?
All right.
Case number 2480941. All right, so we should dismiss the claimant's late appeal to the commission. Regarding the timeliness of the claimant's appeal, the AT2 decision was issued to the claimant with an appeal deadline of April 8, 2020. The claimant faxed her appeal on September 9, 2020, over 5 months late. The claimant did not explain why her appeal was late, nor did she misinformation from a TWC representative or technical difficulties with the TWC system prevented her from filing a timely appeal. As such, her appeal is late, and we do not have jurisdiction to consider the underlying merits of this case. Accordingly, we should dismiss the claimant's appeal to the commission as late and leave the underlying AT2 decision in full force and effect.
Thank you. This leaves a majority vote of a late CA. Chairman Daniel, I have your vote recorded as dismissed because the appeal is late to Commission Appeals. Is that accurate?
That's accurate.
And Commissioner Alvarez, I have a short form dissent on your behalf. Is that accurate?
That's correct, ma'am.
Thank you. And we can turn to the other case that you mentioned, which is the 12th case, case number 2602420. Commissioner Alvarez?
Yes, ma'am. So my vote was to reverse the AT, no misconduct, no chargeback, disaster, and sever valid claim issue.
Yes.
And Chairman?
My vote was to reverse the AT, no misconduct, chargeback, several.
Okay.
So with that said, Ms. Miller, I would agree with Chairman on this case.
All right. Thank you for going back. Majority vote is no misconduct, chargeback, sever validity of claim issue. And Commissioner Demerson, I have a short form dissent for you.
Go ahead and maintain Yeah, short form dissent is fine.
Thank you, sir. Mr. Chairman, is there anything else you'd like to cover?
I think we've covered it.
All right, then that is the last of the pulled cases on docket 50. You should have received the UI short form dissent list earlier in the meeting.
Mr.
Can I
Chairman,
move we- please?
before you move, let me look at case, one other case before we move on.
Absolutely.
Okay, it's case number 92588-959.
2588959.
2588959.
Yes, sir, you pulled this case.
Yeah, and I think I wanted to change my vote in this case. I maintain my previous dissent.
Yes, sir, I have you as a short form dissent and we will record it as maintained.
Thank you so much for that.
Thank you. Any commissioner want to cover anything else?
No,
Well, I
ma'am,
would
thank
move
you.
to accept staff recommendations on the remaining UI cases on docket 50.
I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 50.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 50.
The motion passes with the exceptions noted.
Thank you, Mr. Chairman. I wish all of you commissioners a very happy holiday. This is the last docket meeting of the year. I appreciate everything you do for the agency, and it's my pleasure to be here each week to assist you. Merry Christmas.
Well, likewise, Ms. Miller, thank you so much for that, and happy holidays to you, and looking forward to seeing you in the next year.
Thank you, sir.
Thank you, Ms. Miller, and your staff for everything they do.
Thank you, Commissioner.
I concur with both of my fellow commissioners this year. Thank you guys for everything.
There you go.
Yes, sir.
Ms.
Thank
Miller-
you, sir.
Ms. Miller, record that as a unanimous vote.
I will. Thank you, sir.
And that brings us to the end of agenda items 3 through 7. If we would, let's pause for just a few minutes to reset for the rest of the meeting. Oh my.
All right.
All right, is everybody ready?
Yes, sir. Tackle it.
All right, we'll start with agenda item 8, but staff has nothing to present for agenda item 8. We'll move to agenda item 9, high demand occupations report. This discussion serious possible action regarding the annual report to the governor, lieutenant governor, and legislature considering existing projected shortages and like building requirements.
Good morning, Chair Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, my name is Mariana Vega. I'm the Director for the Labor Market and Career Information Department. And today, for your consideration and possible action, you do have before you the annual commission report on growth occupations to the governor, lieutenant governor, and legislature regarding existing and projected shortages in high wage, high demand occupations. Your offices did receive a copy, and you were briefed on the report earlier or last month. For this report, we did examine over 800 occupations to show the most in-demand occupations for the 2018 to 2028 period for the 14 major industry sectors as specified in Texas Labor Code 302. To produce the report, we did use various BLS data sets. We used Employment Training Administration long-term projections, as well as Labor Insights Burning Glass real-time online job postings. I would like to thank the LMCI team led by Gabriel Guzman. They put this report together, and today we are asking for commission approval of the report with permission to make minor non-substantive changes as we prepare the final report that will go on our website. That does conclude my remarks. Thank you for your consideration.
Any comments or questions?
Chairman, I was able to hear Harrison Keller and Mike Morath last Friday at the Quick's meeting. I was very impressed that they acknowledged the great work that our LMCI department does. Great information. So I just wanted to make it on the record.
Other comments or questions?
I just thought, Mariana, thank you guys for the work. Thank you for the.
Is there a motion on this item?
Yes, sir. I move that we approve and submit the report on the Texas growth occupations to the governor and legislature as presented.
A second.
It's been moved and seconded, and we're unanimous. This is item 10, discussion, consideration, possible action regarding the repeal of the Texas Administrative Code, Chapter 841, Workforce Investment Act, and the adoption of new 40 TAC, Chapter 840, WIOA eligible training providers, new TAC Chapter 842, WIOA non-discrimination equal opportunity, new 40 TAC Chapter 802, Subchapter J, local workforce development area appeals. This was previously published for public comment in the October 9th, 2020 issue of the Texas Register.
Hi, good morning, Chairman, Commissioners, Mr. Cerna. For the record, I'm Joel Mullins with Workforce Development. TWC's Chapter 841 Workforce Investment Act rules that provisions related to the maintenance of a one-stop delivery system, training provider certification, non-discrimination and equal opportunity, and appeals of denial of local workforce development area certifications. On September 8th, the Commission approved proposed rules related to the repeal of Chapter 841, new Chapter 840 on eligible training providers, new Chapter 842 on Wioa non-discrimination and equal opportunity, new Subchapter J of Chapter 802 on local work development area appeals. The proposed rules were published in the October 9th, 2020 issue of the Texas Register for a 30-day public comment period. No comments were received on Chapters 802, 841, and 842. However, some comments were received on Chapter 840. Based on these comments, staff have identified some opportunities to add more clarity to and improve the final rule and have revised sections 840.20 and 840.64 accordingly. This morning, staff seeks direction on adoption of the final rules as provided in your meeting materials. Repeal of Chapter 841, new Chapter 840, new Chapter 842, and new Chapter 802, Subchapter J. And I'll be happy to answer any questions that you have.
Any comments or questions?
None here, Chairman.
None.
Do we have a motion on this issue?
I move that we adopt the rule amendments regarding the repeal of Chapter 841, the creation of Chapters 840 and 842, and the amendments of Chapter 802 as discussed.
A second.
It's been moved and seconded. We're unanimous.
Thank you.
Thank you. This will bring us to item 11, discussion, consideration, and possible action on the submission of the 2020 Texas Workforce Commission Supplemental Annual Report, also known as a Consolidated Report, to the Governor and Texas Legislature pursuant to Texas Labor Code Section 301.065C and the Texas Human Resources Code Section 122.022A.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, it's Margaret Hessian, Director of Communications. Today, for your consideration and possible action, you have before you TWC's 2020 supplemental report to the Governor and Texas Legislature for your consideration and approval. The report is submitted in accordance with SB 1413 enacted by the 86th Texas Legislature. The report contains the following TWC programs: College Credit for Heroes, Skills Development Fund, the TAA or Trade Assessment Adjustment, and Works Wonders, Texas Purchasing for People with Disabilities. We are requesting approval of this 2020 supplemental report with your permission to make any technical corrections as necessary. Finally, we have subject matter experts available for questions should you have any, and we're prepared to answer any questions, Chairman.
All right, any comments or questions?
I'd just like to take this opportunity to thank Margaret and her team for a great report, very informative.
Thank you, Commissioner.
You're welcome.
No questions, comments?
All right, do we have a motion on this issue?
Chairman, I move that we approve the supplemental annual report, consolidated report pursuant to Texas Labor Code Section 301.065C of the Texas Human Resource Code Section 122.022A and submit the report to the Governor and the Texas Legislature.
Second.
Been moved and seconded. We're unanimous.
Thank you so much, Chairman and Commissioners.
Thank you.
Happy holidays.
Happy holidays to you. Let's move to item 12, discussion, consideration, possible action on resource utilization of funds donated to the Texas Workforce Commission by the Ikea U.S. Community Foundation. Proposed initiatives respond to the COVID-19 disaster, provide information and tools to Texans to move up in their careers, and provide analytics and trend data to inform Texas businesses in this new Texas.
Good morning, Commissioners. Mr. Cerna, coordinate our board workforce division. The Ikea Foundation provided a generous donation to TWC in an amount of $4,900,125, and the donation was accepted by the Commission on December 1st, 2020. Today, I'd like to summarize for you the planned uses of those dollars with initiatives that support Texans and Texas businesses impacted by COVID-19. The discussion paper, which is posted online as a resource for the meeting, provides greater detail than what I'll share in my summary today, and that has been briefed to your staff a few times in recent weeks. The goal of these initiatives is to equip and enable individuals with information and tools to advance in their career through educational tools and programs, including apprenticeship, online learning platforms, grants and real-time labor market information, and information and connection to jobs. Texas businesses will be supported through industry data analytics, online training videos, and tools to help adapt them to remote and contactless operations. And Commissioners, of the funds donated, if all the initiatives are approved today, a balance of approximately $423,000 remains. Mary York, joins me here to answer any questions that you might have about some of the initiatives for which she's the main point of contact. Okay, the planned initiatives include, first, pre-apprenticeship grants. Local workforce boards, independent school districts, and community technical and public state colleges will be eligible to apply for the dollars, and they'll help in and out of school youth to gain experience and credit toward entry into a registered apprenticeship program or post-secondary education. Funds might be used for curricula, tuition, instructor cost, and for the basic tools and safety equipment that support job training. If you don't have questions about that, I'll go to the next one. The second initiative will provide program consumables for certain training projects. Funds would be made available through the Jobs for Education in Texas RFA, or JET, as well as the Pre-Apprenticeship RFA, and potentially others. And the idea would be that we would be funding consumables, which, as you know, make up a considerable amount of a budget for certain training programs. Only consumables that directly support job training would be funded. Third, a Texas-specific retail survey would be initiated. with the purpose of informing retailers on how consumers have and will continue to change their buying behaviors. The study will seek to address certain research questions about online buying, how consumers are now identifying sales, using coupons and discounts, and how they now get their news that informs their shopping behavior. The next initiative is a cell phone retail data analysis. Sophisticated use of consumer cell phone data shows when customers are now traveling to specific areas where they eat, shop, frequency of visits to the area, and a host of other important data that can be used to inform businesses in their marketing strategies and also their workforce development. Boards would select a combination of local, rural, and urban businesses to participate so that they can understand so that those employers can understand how to leverage the information to design marketing strategies for targeting their customer base. The next initiative is an online retail and restaurant video project for urban and rural businesses. Texas businesses have been able to adapt to the new realities of COVID-19, including online ordering, curbside pickup, delivery, e-commerce platforms, customer service practices, etc. And they continue to successfully adapt. But this project is designed to develop a series of videos in English and Spanish for restaurants and retail employers to train their workforce online and take advantage of these trends. And these videos would be made available online in the months and years ahead. The My Texas Careers job matching portal allows Texas employers to post their jobs online, and for job seekers who otherwise might not use our workforce solutions system or need to fully register in our system the way mandatory participants do, to use this streamlined portal to upload resume, find jobs quickly with an abbreviated registration process. It features resume upload. It also directs people to our workintexas.com system and other online learning opportunities that we've made available. Last, the Helping Offices Manage Electronically or Home project would be funded. Commissioners, as you know, COVID-19 impacted Texas and the national economy, and a number of businesses had to temporarily close for safety reasons. They had to transition employees home for short-term telework, and many have gone full-time telework. Also transitioning to contactless service. This has come at a high cost for some employers and has required new expertise and new tools that have been costly. So the funds would be provided locally to support businesses who need assistance with transitioning, maybe costs associated with digital marketing, signage, moving sales online, expanded email platforms, and others. If commissioners, you have no questions for me on any of those initiatives, I would ask for your consideration on them. I mentioned earlier that with these planned uses listed above, we anticipate a remaining balance of about $423,000. And in addition to your approval of these initiatives or your consideration, I would also ask that we have some latitude at the staff level to make adjustments to some of the amounts if the technical aspects of these initiatives come in higher cost than what our early research has shown.
Any comments or questions?
Chairman, I'd like to thank everyone who was part of this gift process. I'm excited about the opportunity to use this funding that was awarded to us by Ikea, and I wanted to thank them personally, or at least make it noted that we're very grateful for this. I'd also like to thank Courtney, Les, Mary York, or I'm not sure how you called her, Courtney, but I'm very grateful for the outside the box thinking and for the initiatives brought forth. So thank you for that, and working so closely with the three commissioners' offices. Courtney, you answered one of my questions, which was what was going to be the remaining balance, which resulted in about $423,000 plus some change. So that's good. My question is, because I had a list of questions, one of them would be, would there be any restrictions or requirements associated with the Ikea funding? Are there any restrictions? Is it pretty flexible?
Yes, Commissioner Alvarez, when we've talked with Ikea, they've indicated that they're really supportive of whatever states would like to do with the dollars, and they are very flexible in use of funds.
I've seen what they've done in other parts of the country, so thank you again for thinking outside the box and for those that were directly involved in this. And I think contracts and other folks were involved, Christina Ramos and her team, so thank you for that. Those are my comments for this time.
Mr. Chairman, I too like to thank Ikea, a major employer here in the state, for this generous grant, this donation, and also thanks to the team, Courtney, Mary York is the name there, Mary, and all the others that have been involved in this. This is an initiative that's come forward, and proposals that are laid out should be worthwhile to both employers and employees here in our state.
All right. Well, I too would like to thank the Ikea U.S. Community Foundation for this these funds that have been available to the Workforce Commission. I think there's a lot of. I do have some questions about some of the items specifically here on the list, and questions as well. Yeah, I'm a little concerned that we made a list. It's a good list. I think there's some good projects on here, but I do have a question as to why perhaps we didn't set a broader framework and accept applications and for applications and see what other ideas are out there. And in other words, the commission might have passed a broader framework for the program, hitting some key issues. Seems like most of these have in common putting people back to work, so that there's a theme that emerges quickly. Why did we choose to do these specific initiatives and not maybe have a more broader framework that could let some other ideas come into the mix?
Chairman, the inputs onto the use of these dollars were numerous, and I think they were based on what has been heard from various stakeholders about stated needs or areas where there was an interest in expanding resources. When we talked with Ikea, we did share with them that the overarching goal here is to really support Texans and Texas employers in some of the ways I mentioned in my comments, and that there are a number of ways to do that. And so the list was larger and it sort of narrowed to this as we continued discussions.
What test did you use to determine if something made the list or didn't make the list?
I would say that as we talked as an executive team and talked internally about some of these different initiatives, if it was something that we had heard recently that is of interest or a known need to employers, for instance, that it was prioritized on the job seeker front. We know that getting back to work and upskilling and putting resources in the hands of Texans is more important than ever now. So really that was kind of the framework for a lot of this.
Mm-hmm. Was there anything that was considered but didn't make the list due to funding availability?
We had, I don't know that it was because of funding availability, Chairman. We did have a brainstorming session or 2 or 5 about this with executive staff and Mr. Cerna. And there were some ideas that we vetted that didn't make the list, but I don't believe it was for lack of dollars. Okay.
The list that's before us, is that in any kind of order of priority?
No, we just listed them.
Got it. So you know what the available balance is, which means you must know how the funds are going to be distributed among the projects. That's not listed here today. What was your mechanism for deciding how much funds were going to be associated with each project?
Yeah, and yes, Chairman, when we briefed your offices, we've shared preliminary numbers in other draft documents, letting everybody know what we anticipate those costs to be. And in some cases, it was based on what we thought, particularly the more technical aspects of this. The estimates were based on what we thought it would cost to do that, which is why I asked for some flexibility to leverage remaining balances if those come in higher than planned. In other areas, there were just, we might have compared some of these to what we would have done in a normal, like Wioa funded or TANA funded RFA.
Okay. I have some questions about the list of items, just some specific questions on each one. For example, on pre-apprenticeship, it's first here on the list. What specific pre-apprenticeship strategies and activities do we intend this project to cover?
This project is intended to help in-school and out-of-school youth gain skills and education that will push them either into a registered apprenticeship program or into higher ed. The model is intended to help students gain some preliminary skills as they transition into the next phase.
So is this classroom instruction? Is it extracurricular type activities? Is it some sort of summer programming? I guess I'm curious as to what exact mechanism we're talking about here.
The model, I believe, is pretty flexible. We don't have a lot of pre-apprenticeship in Texas at this time. With this, we've used pretty flexible models where it's high schools, boards can apply, and there would be an on-the-job, like other apprenticeship programs, there is a hands-on component and a classroom component.
Mm-hmm. Are the pre-apprenticeship, we've been doing a lot of work in apprenticeships here lately, and rightly so. Solid program, and one that I'm glad that TWC champions. Are these pre-apprenticeship activities not eligible for our other apprenticeship dollars? I think there's an excess of $10 million still available for apprenticeship activities. Are these pre-apprenticeship activities not eligible for those dollars?
Pre-apprenticeship is allowable with the Chapter 133, and I believe you're referencing the DOL expansion grant that we have. Pre-apprenticeship is an allowable activity in those grants. In this RFA that was published, Chairman, I'm not sure if we called out pre-apprenticeship. I can confirm and brief your office.
Let me articulate a concern I have about this particular item. So on its merits, this is a worthwhile thing for TWC to consider doing. My concern is that the Ikea Community Foundation gift is a one-time source of money. And so we would dedicate resources from this one-time source of money to something that I think should be an ongoing program. I think that pre-apprenticeship should always be part of our apprenticeship mix. I think that students should experience good and solid CTE programming early in their educational career, middle school, early high school, so that they're prepared to enter and perhaps expedite their completion of either a registered apprenticeship program or an IRAP. And I'm very concerned about putting one-time money to a program that I want to know has sustainable funds for the future. Did you consider that at all? And is there a way to make this more sustainable for the future? If I was the sole decision maker today, and I'm not, but if I were the sole decision maker today, I would set this aside and ask you to find me a more sustainable source of funds than the IKEA funds. I think there's plenty of uses for the IKEA funds and one-time expenditures, so that we have a much more robust pre-apprenticeship offering. So my question to you is there a more sustainable source of funds, and why wouldn't we shift that over to those funds right now?
Well, Chairman, as I mentioned, both the Chapter 133 fund there allows for pre-apprenticeship training, as does the DOL expansion grant, or those that we've been fortunate to be awarded so far. We can, in effort to build pre-apprenticeship, do more outreach specific to working with, often in pre-apprenticeship, you're working with younger students who are trying to kind of get their feet wet in the program. We can increase our outreach in these. And Commissioner Alvarez, did you want to?
Yes. Okay. Yes, so we do not want to use DOL expansion grant money because we have specific goals and targets. We've stated that in the past when it came to the expansion grant. And so we have performance measures. Why not use, that's why one of my questions, so I'm glad we're going to be bringing up questions regarding these initiatives, because I didn't have many, but I do now have some. regarding this issue and the agenda items that will be coming up. So there's no restrictions. Why not use this as a pilot program? This is a perfect opportunity. My legislative proposals or my exceptional item asked to the legislature, we did not get it as a result of asking the legislature for some money. Here's an opportunity. We got a wish list. We're able to use money for pre-apprenticeship. In the TWIC meeting, there was some discussion that pre-apprenticeship was going to be listed as an IBC on the IBC list, which it isn't now. There's a distinction between IRAP, pre-apprenticeship, apprenticeship, and CTE courses. But my main concern is we cannot do this because we will not hit, first of all, two things was my rationale for this initiative. Because it's something we don't do now, and there's flexibility in how we can use the money. Two is the DOA expansion grant money is to use for specific goals, targets, and performance. We may not meet them with this. Why not use this money as an opportunity for us to try a pilot program? The other thing is, going back to early statements on how this money is being used, if you look at how the other states have used this money, it was none of them were using it for training. They were using it and awarding it to nonprofits for food, housing, paying rent, paying light. I think what the staff has put forth is a great plan. That's just my opinion, but you know, I just thought this would be a good opportunity, Chairman and Commissioner, for us to try this as a pilot program. It's 1 million. We want to go back to what staff has given us as far as the amounts. I don't think that's a large cost. And again, listening to the conversation that took place at last Friday's TWIC meeting, reference to pre-apprenticeship was referenced multiple times. Why not do it? Those are my comments.
About how many students would this effort serve?
It's hard to predict that, Chairman, because we don't have any national, I've looked for an average cost per on pre-apprenticeship. Commissioner Alvarez, if you know, please speak up. I'll tell you the cost per on Chapter 133 is pretty low. If it was more than 3,500, 4,500 per student, I would be pretty surprised, but that's just a guess on my part based on what we see in other training programs for youth.
We're not paying close to that at all.
Yeah,
Cost
in
per is
133.
about $1,800, the same as Chapter 133.
Right. And
I mean, we've been
Commissioner,
around this, yeah.
I'm just not sure about the youth piece of it. And we would seek to keep the cost per low to be able to serve as many students as we could.
I didn't know we were going to go by these, but then I'm going to have a list of questions following the chairman's remarks regarding some of these initiatives as well.
So if I'm not sure how many students we're going to serve, we probably don't also have an idea of how many jobs we think this might ultimately lead to. That's a hard question. I understand. I'm just curious.
Well, the primary goals of this, and you may have seen that DOL even put out a notice this week about youth build and making funds available specific to this. And I think their goals are similar. It's trying to help students get information and some basic skills toward going into either a registered program or into higher ed. So the path to employment may be long, but the idea is to get them hooked in a targeted industry or an industry that's in demand in their area so that they can go on and complete and get more education toward that.
And Courtney, I know that a pre-apprentice leads to a registered apprenticeship program. So we can track if these individuals are placed into employment. So he has a job from day one, if I'm not mistaken.
That's true. If the student goes into a registered program, he begins earning a wage immediately. If he goes into higher ed from this jumping point, it may be a little longer path, but if he goes into registered apprenticeship, he'll be earning from the point that he enters that program.
But did we not create a crosswalk with the help of Texas Higher Education Coordinating Board, Dr. Sally Janes? We have multiple colleges around the state. We had this meeting at Austin Community College where many folks did not know that there is a bridge program. We did create a crosswalk where Del Mar will accept over 30 hours and various schools around the state will accept hours. So there is a career path that follows the tri-agency report and the report that's on the website that we currently have right now. I'm not sure if there's anything else, but I'd be more than happy to answer questions.
At what point does the student make the decision whether to enter the registered apprenticeship program or to go on for higher education? Is that any kind of line of demarcation, or is that just a student decision that gets made during the education process?
I would say that ideally, when we build this model and we make the applications for funds available, that anyone that is preparing students for courses at the local community college or into higher ed, that they have some level of agreement with the college or a pathway that they're working with the students to pursue. If there's not a registered program that they can springboard into, that they may help the student make the connection into community college.
Okay. Let me switch gears a little bit and talk about the second item on the list.
Chairman, before we move, since we're talking about pre-apprenticeship, can I just remind the commission that we just got a letter from Department of Education that allows us to use pre-ETS money to help those with the job exploration, thanks to Ms. Cheryl Fuller, and the letter that we submitted to the Department of Labor and Education. So there is this thing about pre-apprenticeship, and it's got a lot of momentum. It will help with those individuals that are going to go into the IRAP program. There's a correlation between all of these programs, but we just do not, as Courtney referenced earlier, have a pre-apprenticeship program in Texas. Northside ISD has a registered apprenticeship program, a full-fledged registered by DOL. Humble, Texas wants to do the same, but this is a good way for us to introduce apprenticeship programs at the high school level. Trio Electric, who we're all familiar with, have campuses now in Austin, has a pre-apprenticeship program. This is financed by Bo Pollock out of his own pocket. And so I just wanted to remind folks that this program has been very successful. We've had it in Austin, Dallas, San Antonio, and now we're obviously in Houston. And Bo Pollock is working on projects with high school students here in Austin as we speak. So before we move on, I just did want to mention that, if that, I thought it was appropriate before I come back to that.
Mr. Chairman, if on that same issue, and this is either to Courtney or Commissioner Alvarez, in terms of employers in this initiative, you guys spoken with employers that are excited about this or not excited about it, and feedback in that area?
I haven't heard not one person that's not excited, and I'll let Courtney talk. We've had conversations like many of you with Tesla or the school districts or workforce boards. This was the same discussion that we had when we talked about the co-located educational specialists. And we saw how that was. It's a pilot program. It's done well. And I understand the concern, but this is just another tool in our tool belt that we can use to train folks early on the value of trades, just no different than what we're going to do with people with a disability when they're doing job exploration with pre-ETS money. Once they've decided that they want to go into a certain career path, these individuals will now be shifted over from pre-ETS to apprenticeship or whatever, or VR resources that we have. But I haven't heard one employer, matter of fact, I think all of us have talked to employers that have talked about the value of trades. If we haven't, I'd sure like to know who they are.
Commissioner, I'm excited to hear you mention Tesla. I've had an opportunity to visit with them on occasion, and in one of their handouts, they had mentioned apprenticeship programs and the like, and there's probably a number of employers, but just curious about employers in particular, and good to hear you talk about some of those that might have an interest.
On program consumables, specific programs, does this effort contemplate funding consumables for?
The JET program and this pre-apprenticeship program would be the primary projects.
And do we currently fund consumables for those programs?
In statewide initiatives, no, we do not currently fund consumables.
So this constitutes a bit of a policy change for the agency.
I think the commission could determine whether you wanted to make allowances for these donated dollars in comparison to other programs. But yes, this would be providing consumables in those two RFAs would be outside of the norm for some of the other RFAs we initiate.
Okay. And then, correct me if I'm mistaken here, but if I'm remembering correctly, TWC changed our policy on consumables and the funding of consumables in 2018.
I would not be able to tell you the exact year, and I think you might be referencing the JET program.
Okay.
I'm not sure about the year, but after the program transitioned over, there were some consumables that were funded, and then the agency made a decision that in those grant awards, it would be more focused on equipment and supplies that are related to the equipment and not about the short-term use consumables.
And so under this initiative, then we would have JET program recipients who would not be able to purchase consumables, and then some cohort of JET program recipients who would be able to purchase consumables.
In this next RFA, that is correct. The idea here is that in the next RFA, we would indicate that because of some donated dollars that consumables would be allowable.
And when the money runs out, because I'm not exactly sure how many dollars we've allocated to this particular function, we can't even ensure that everyone who's applying for a JET grant or possibly a pre-apprenticeship grant, that the money would even hold out long enough to fund everybody during that application period.
We've talked a little bit about how to spread the dollars based on the number of applications we think we might have in both the JET and the pre-apprenticeship program. And we could set a percentage limit, a percent of your total ask could be used, or maybe the percent of the equipment dollars, 10% of that is one of the numbers we were considering. We could also look and give a proportionate share to applicants if there were more applications than the dollars would allow for, at a 10% amount, for instance. But we could, at the staff level, find a way to stretch the dollars across the applications this is funded.
So is it fair for me to characterize it as you've not made that decision yet?
We've made some early planning decisions, but if there was concern about ensuring that every application was funded, if they had a request, we could spread it differently. We first were working with maybe a 10% of award amount or 10% of equipment cost amount. But again, that was an early estimate.
Okay. And then is our thinking here that after that round for which the Ikea dollars might be available, that we would then shift back to our standing policy of not funding consumables?
That is my understanding, yes, that this would just be one-time donation. It would be allowed with this donation.
And there would be no consideration given to JET applicants who are just beginning their project.
Correct. This would be out of scope for past RFAs. It would be included in the next RFA.
Do we have a sense of, like, in terms of this effort, how many additional jobs it might create for having these consumables?
I am not able to answer that, Chairman. I don't know how it would. These dollars actually go to the training provider to support the cost of the training that is provided. So kind of like other initiatives, there's a benefit to the employer, but it may be down the road.
My primary concern here is that we can get people to work in a job that they want to have. There's unfilled jobs on work in Texas right now. There's people who are on unemployment benefits that would like to go back to work. And I'm trying to sort of determine for all of these types of initiatives, just some idea of what we think how this would further that goal. For example, through our conversation here today on pre-apprenticeship, I can see a link between someone participating in pre-apprenticeship, then registered apprenticeship. That's certainly going to lead to a job. An employer is going to have solid employee, and another Texan's going to have a great career path because of their journey through the apprenticeship program. I can see that, and I can appreciate that we might not know the exact number. I'm having a harder time understanding how a one-time funding of consumables on a small universe of a much larger ongoing program is going to create more jobs for people or more opportunities for people to get into jobs. And so I'm just looking for a little bit of the thinking on that and maybe how that came together along those lines.
Chairman, if I may add, on some of the schools that I've attended on some of these grant presentations or JET grant presentations, it's challenging for people in Hebronville, San Diego, Texas, to afford solder or helmets or boots or things like that, because the JET grant does not pay for that. And so my rationale was for those schools like in Rockdale that don't have the luxury of having the funding to pay for everything they need, whether it's syringes or, like I said, solder or some of the other things. And really this discussion for many years has been part of when before Emily changed her last name, and the JET advisory committees has always been, is there ways that we could increase the funding or make it allowable so that some of those that receive software, IT equipment could purchase software? So when you talk about leading to jobs, you're providing equipment that allows these individuals to continue their training and not have to stop because they did not get soldering equipment donated in a small town like Hebronville or Alice, Texas, or places like that. And then the other thing is, I just can't imagine that the JET Advisory Committee would not agree to something like this, a one-time thing. I think this is a good initiative. As I said, I compared this to some of the other initiatives that were being done around the state. And we were really good in my opening remarks by referencing thinking outside the box. This is an opportunity as to use our money as flexible as possible. You know, if I was given a list of things that I could do with TANF for SNAP, sometimes I can't do it because of the restrictions I have. In this particular case, I want to thank your office for working with the Ikea folks for getting the money, but I also acknowledge staff for working so hard in how they were going to lay this out. So my argument to this item that you're talking about, it does not cover PPE equipment that TEA pays for. It's more for things as I've gone to different places for these JET grants where they tell me, if I ask them, if you had one wish, what would it be? And it's always been, God, if you could just help us with some of the things that we cannot pay for because the grant doesn't allow us to. So a one-time infusion is not really a bad idea, and it does help with training.
Commissioner Alvarez, I think it helps with training, and Chairman, it's not going to lead to a number of jobs. This particular item, when you're purchasing disposable gloves, plastic containers, syringes, those kind of things, those are not going to lead to a job. They aid in whatever it is that that this either high school or community college, their training aspects, and so that's where we are with this one. Basically, when I look at it, it's a consumable item. It's not the equipment grant. It's something that when the JET program in this particular instance was first started, a lot of individuals came in with consumables, hard to track, is it a consumable, is it not, et cetera. Thing with Commissioner Alvarez is attempting, if it's Commissioner Alvarez, I'm not sure, but what attempted here is basically to address some of those needs that were sought out early on using a one-time aspect. This Ikea is definitely something different without a lot of strings tied to it. And I think that's probably the approach there. But leading to jobs, you're not going to see that, in my opinion. There's not going to be a lot of jobs there. It's an item that adds to what some of those communities may have wanted. On the staff side, I shared this with Courtney and those guys. It's a one-time aspect. You want to make sure you don't confuse the message that you had consumables, you don't have consumables, and now you have consumables. Again, won't have it in the future. That message needs to go out if this is approved and the like. And then in the sense of adding it to an RFA, I don't know if that's onerous in itself, but that's on the staff side. I know the attempt with this consumable, it's a one-time type aspect. It is basically what it is. Basically, disposable gloves, some other things, boots that Commissioner Alvarez mentioned, but it's not going to be the equipment because the JET program handles the equipment. This is just simply a consumable item, period.
Aaron, when you, or Commissioner, when you oversaw this office and you would lead these, these meetings with, the advisory committee, Mario and many of those that were on the board had informed us that they were hoping that at some point, maybe we would even think about using some of the JET funding for consumables.
Yeah,
And so that's been referenced, and it does lead to jobs. You cut off the solder in a small town, that kid is not going to be in a lab. So it does lead to jobs. These kids upon graduation in those small towns are directly being employed right out of high school with the credential, keep in mind, with the credential. So it does lead to a job.
Yeah. And so the training that they're taking place, that's taking place, that's the job that it leads to. The consumables, again, add on to what they're doing in that respect. And I think this particular item is probably, it's one time. It is a one-time approach to that aspect. The JET Advisory Board, yes, they were always excited about doing more for the IS and the community colleges. Anything they could do to add to it, they wanted to do that. But we, I think at staff level, had determined that it was basically it's an equipment grant program, and we wanted to stick there. I think this initiative is basically to address some of those other
Complements
concerns.
it.
Yeah.
So my fellow commissioners both seem to be in support of consumables. Why is that not TWC policy right now?
Yeah,
Well, that's what we're doing today, I think.
My answer, basically, I think our policy that we have in a sense, or if it's a policy that we're not supporting consumables, it's good. This one-time aspect is something, that's the way I'm looking at this thing. It's a one-time aspect. It's not going to be anything that's continuing. Now, if the JET Advisory Board comes up at some point and says, you know what, we want to add consumables, that's something you guys, Chair, as chairing that committee or that advisory group, would have to consider if the legislative body states that we'd like to allocate funds for consumables. That's something that takes place on those sides. But my idea here, the generous donation by Ikea allows us great flexibility with these funds. And from that standpoint, when I saw this, I didn't have I wasn't hard pressed against it. My only thing was for the staff, how you guys going to implement it? And then making sure that the messaging is clear, that if approved, it's one time and you don't get a confusing message that JET allows consumables from that standpoint. So
Chairman, I know that I've had discussions with members and they have stated, more than one member has stated, would you all like to see more money go to the JET program? So they know that that is a win-win, especially when we have these events and we invite them. They see that those are game changers in their community. I have no doubt that if we do get money, who knows, maybe we could implement that. I mean, you oversee the advisory committee. Who's to say that this one-time pilot program or program that we're going to put in place won't have an effect on the advisory committee and say, hey, why not do it? Continue funding.
Was it the advisory committee that changed the policy from doing consumables to not doing consumables?
I don't think we've ever had the ability to do consumables. It was just they voted not to fund consumables. It was just more of equipment.
I understand is as recently as 2017, consumables were permissible under the JET program.
Yeah, there are consumables, and boy, I tell you, you had things coming in, consumable items that you probably said, you know, we probably shouldn't be paying for that. And I think that's where the decision probably was made at the staff level that we would probably not do consumables from that standpoint, because the program was set out for equipment. It was an equipment grant program, or an equipment grant program, and you kept yourself out of a lot of questions or other things by sticking to equipment in that particular case. And so, again, these one-time funds from Ikea are outside of the appropriations from the legislature. And so I think that's what's been approached there. And if consumables is something that the agency or elected officials are interested in, you know, that would probably be advocated at some point and pushed forward. You know, that's how that got added and taken out.
I'm completely unaware of any legislative prohibition on consumables.
No, probably none.
I've read the statute. I don't see one. And yet our policy is not to. My concern here, just so I can be clear, is I can understand if you purchase equipment via a program for a school, new equipment for a new training program, that perhaps the first year's materials that make that equipment run might be necessary. I might change the discussion a little and say, if I bought someone a lawnmower, I might send it with a full tank of gas so that you could get started immediately. All right, that oversimplifies it. If I bought a welder, I might, put some allowance in there for spools of wire for the welder for some period of time to ensure that things got off to the right start. I think that's good policy. I think that our TWC policy on consumables is probably not the best policy. I don't think that a budget discussion is the place to introduce a policy change. If we want a policy change, let's just execute a policy change. I think that all the rationale for why consumables should be or not be included in a JET program grant, I think they lean towards certain consumables should always be considered eligible under that grant. Let me tell you my concern here, and it's very specific. My questions regarding the sustainability of any of these programs, I'm going to ask it every time on every one of these programs. This one is the one that causes me the most concern for the agency. I find it problematic for this agency to have 1 year of consumable eligibility simply because Ikea was kind enough to make a contribution to the state. I think that Ikea's generosity is amazing, and I want to put it to good work. I don't want to come back a year from now and have to tell the next group, no consumables for you, because no one else made a very generous contribution to the state to ensure that people could get the kind of job that they're looking for.
Chairman, let me ask you, how is that any different than the $2 million we're getting from TEA, and we're going to infuse $2 million this year, and we may not do it next year?
That's an overall budgetary. This is a very specific policy item.
Which could be used as a pilot program.
It's not styled as a pilot program here. Nowhere did we use the words program.
I agree.
Experiment to see if this is going to work, if this is a good thing, if this is an experiment for us to try to understand the parameters of the consumables, Commissioner Alvarez, then I agree with you. But this needs to be here in writing. This is not in this item. It doesn't say pilot program. It doesn't say we're trying to sort out the best way to do this. If that's our intent today, and the net result of this discussion is that's what the intent of this is, then I'm leaning way more toward supporting it than I was, because I'm not looking forward to a conversation 12 months from now where we have to tell the next group of people, no, not now, just simply because we made a one-time decision. You make an excellent point.
I do know that this is just a summary. We could always ask staff to come back with the data, but I agree with you, Chairman, on some of the remarks that you're making on these things. But again, I just can't see that if we have an opportunity here to provide underserved individuals or school districts with opportunities to purchase equipment, consumables especially, how we wouldn't take advantage of it, especially if we were to bring this up to the advisory committee. I would say they would probably be all in agreement. At least I'm hoping that they would, and say, hey, we did it one time. And going back to the analogy that you used, let's assume you did buy that lawnmower, but once you run out of gas, you have no more, you can't cut the yard. But if you get money from a neighbor and says, here's $50 so you can cut the yard, that's no different than if we were to buy IT equipment and the software is outdated. That was kind of the rationale behind this as well. So I'm not going to be pressed hard on this thing because I think it's a good initiative. We put a lot of thought into the initiatives that we brought forth, which were the pre-apprenticeship and the consumables. We put a lot of thought and a lot of work behind it, not only with staff, but with consumers, employers, school districts. It wasn't something that we just drafted up or thought about. And so I'm not sure what else I could add to that, but we have talked about this for some time now regarding the consumables. I just wanted to make it clear it wasn't for PPE equipment. It was for things that kids that could not afford, that TANF and SNAP would not allow us to purchase, the ability to do it at a one time. And if you look at the list that we have, all of these initiatives brought forth are all one-time things. All of them are.
Courtney, excuse me, Commissioners. Courtney, what's the total value of this one item?
The consumables item is about $1 million.
Okay. And the points that the three commissioners have raised have been noted by staff, so that if the commissioners agree and we move forward with this, we can use it as a mechanism for determining whether we should come back to the commission in the future with a recommendation on making a policy change concerning the JET grants more broadly, since this is for future grants, not retroactive for any existing grants. So we can clearly say and clearly message, as Commissioner Demerson has pointed out, that we will, this is a one-time evaluation to determine the real value of adding that type of allowance, that type of an expense to the grant, because it doesn't adversely impact the monies that were allocated, and the commission has already said, go forward with this much for JET for next year. So Mr. Chairman and Commissioners, let me say that it's a significant number, but that if you agree, that staff will use it to evaluate coming back. Now hearing all this conversation, and I was not in the position that I'm in, nor was I engaged in the decision to either allow it way back when or disallow it more recently. But I think with the conversations that we've had and the feedback that I've heard, that staff does need to have a mechanism for evaluating the usefulness, the one-time usefulness, the first tank of gas in the lawnmower, if you will, and that we would in fact use this one-time infusion of funds for that purpose, and come back and report to the commission. Of course, we'll report to the commission on the results of all of the expenditures, but very specifically on the impact that it had, and then the potential future impact on whether we should continue it or not continue it. So to your point, Mr. Chairman, though it wasn't described as that, what I'm hearing is that if the commissioners decide to advance it, that staff should consider it an opportunity to evaluate the usefulness of that kind of expenditure.
I would go one step further. I think this is something that's emerged from today's discussion. I think it needs to be very clearly labeled that it is a pilot program. It is, in essence, almost a study. Although most of the time studies have no action. This has action. It's a good thing. I can see how, as a pilot program, it would help us better understand how consumables would impact the programs. I would want to know that we were specifically listing it as a pilot program, that we were messaging it as such, and that Commissioner Demerson's caveats that this literally is for this one program year for both the JET program and I think the pre-apprenticeship program. And I would say that for $1 million, which I do have a question about how that dollar amount was assigned to that, but that $1 million, if you split it between two programs, meaning pre-apprenticeship and JET, it's just not going to go very far. And so I need for folks to understand this is a pilot program. It's trying to understand the viability of this, and there is no guarantee of consumable money going forward into the future. I'll say that there won't be. I do think the commission needs to come back and revisit this. This seems to be a complete and total policy measure for the commission, and one that it should take up. Perhaps now's not the right time. If staff is willing to commit to those two things, and the commissioners would agree, I think that gives clarity to me and lessens the expectation that somebody got something that somebody else just simply won't be eligible for, because it does make sense that when receiving such a generous opportunity like this that Ikea has presented to us, we might use that to solve some other problems that we're seeing by lowering barriers for people to get the kind of training that they need to get into the workforce.
Yes, sir. That's something that I can assure you that we will do, including coming back and reporting in very much detail the results of this one-time study.
I have a question for Les. Can we bring forward these proposals with the caveat that they're all pilot programs? Because I don't think we want staff to go back and do a discussion paper on this, do we?
No, I think at this point, taking your guidance from the dais here today, we certainly will make the adjustments to our plan moving forward and treat it as such. And I think in ample clarity here presented from you all on this point.
And I apologize, when I read this, this discussion paper and what was brought forth, which little I got, there was no reference of a pilot program. But as I looked at all of these initiatives that were brought forth, to me, they all did look like pilot program type of initiatives. And I thought, hey, if they work, maybe we could fund them in the future. So that was just my take. So in no way did I think that these were going to be pilot programs, but I didn't think that it would hurt that if they did work, the folks from the advisory committee would say, hey, it worked. Let's see what we can do to put some money aside to fund these consumables. And so that was my take on this after reading this. And like I said, I didn't really get much of a discussion paper on this particular item, but what little I did know, I did know that it wasn't going to be used as a pilot program.
So, Mr. Chairman, if I may just quickly, pilot versus one time, I don't know if there's a big difference, whatever, but I basically, when I was looking at these things, it's Ikea, generous donation, one-time opportunity to do some things. Some of the things that I'm interested in, they're one time. I'm not looking at if it's something that staff says, hey, we want to do that every year or so be it. We can go from there. But when I looked at pre-apprentice program consumables, it's a one-time opportunity on consumables. Again, I've stated this because I've been responsible for that JET program. The messaging is going to have to be very important because you've done some and you're not doing them. And so you're going to have to message out big time with that. But one-time generous donation from Ikea. One time, I'm not sure the differences, but for me, it's the one-time opportunity, and we're moving forward from that point.
Yeah, so my concerns fall down a little bit along the same lines. The one-timeness, I was okay with a one-time project for one-time money. And if I could, if there's any objections, certainly I'll hear it. I don't want to dominate the conversation here. But just for my view, if we're going to classify something as a pilot program, which I would agree is appropriate under the circumstances. If I would classify it as a pilot program or a one-time expenditure, and it probably won't come back up, I would do it this way, just so you know my thinking. Pre-apprenticeship, I can, if that is clearly labeled as a pilot program, I can understand why we would use this source of money for that. Consumables, same. Pilot program, clearly labeled, clearly communicated, expectations, not managed, but stated. This would only proceed if it was successful. Retail survey, retail data analysis, and online videos, the next three in line. I would consider those commissioners as a one-time only expenditure. I read that, and I think the intent is clear. We look, just between you and me and everybody who's on the call today, I hope we're not dealing with the same workforce issue a year from now that we're dealing with now in terms of trying to find creative ways to ensure that jobs can continue to get created. I would love to go back to the situation we had before where companies were finding their niche here, thriving, creating jobs, growing jobs, and we were really focused on upskilling, reskilling, and filling the middle skills gap. How I would love to get back to that. That is not the situation we find ourselves in right now, and the taxpayers are expecting us to work on these issues that were dealt. But these three particular programs I would view as one time. And if the economy finds its stride, like some of the numbers are indicating that it might sometime next year, we wouldn't have to come back and revisit those. My Texas Careers, I think we should style that as a pilot program. This is a bit of an extension from workintexas.com. It's an experiment to see if there's a better way to help match employees with employers. I'd say style that as a pilot program. And I think the last one on the list, I would style as a one-time expenditure. I think that offices and businesses are still making some decisions on how they're going to work with their customers and do that. If we style them as such, That gives me a great deal of comfort in terms of how we communicate this and how our expectations are communicated among our customers. If you disagree with my characterization, let's talk about it. But I think putting those labels on there is absolutely critical for helping people understand the nature of the money. The one-time expenditures are exactly that. This is something that we're doing to address the current situation that we find ourselves in. It is a unique set of challenges, and I think it requires a unique set of solutions. I think that there's merit to the pilot programs, apprenticeship, consumables, and My Texas Careers. I think there's merit to using this generous donation to try something new, perhaps a little bit innovative, or perhaps something that's a departure from what we usually do, thinking that it might solve some problems and move forward. Have I characterized that correctly enough for you to be satisfied that was my intent?
Thanks. I'll defer to Commissioner Alvarez, and then I'll comment if Commissioner Alvarez has any. If
Yeah,
not,
I mean, I wish we could have said that at the beginning, to be quite honest with you, Chairman. Because I know you see the value in the ones we brought forward. And I mean, if the motion is to just 2, 3, and 6, which would be, which would be apprenticeship, consumables, and My Texas Careers Job Matching Portal to be pilot programs as a motion, and the other ones to be as a one-time, pilot program for those 3, and the other ones to be just a one-time, I could approve that. But if that's, I don't know. I do have some questions regarding, if you want, about your number 6, My Texas Career Job Matching Portals. I thought it was good, but we can discuss it if you want to now, if you want to get to that item.
I have additional questions, but let me share the floor. So if you have questions, please, this would be a great time to do that. I'll let your questions, perhaps they're the same as some of mine, and then I won't have to ask mine. So please, Commissioner.
So what is the difference between the work in Texas, which is somewhat difficult as it is to some of our clients, to My Texas Career Job Matching Portal? So what is the difference between what we have now? Is that going to make it confusing to what we have available now to someone who's looking for a job? And if it is, why didn't we do it with the work in Texas as currently being done? What makes it any easier? What makes it any easier? So if a legislator says, why did you all have to implement this? Why didn't we make it easier before?
Commissioner Alvarez, that's a great question. With our federal dollars, we are required to report a lot of very specific information about mandatory participants. And that is built into the Work in Texas system so that we can meet our obligations under those federal awards. Not everyone who is looking for work needs to go through that. And while we have hundreds and hundreds of people who do use the Work in Texas system, right now we have people that are looking for work that have not needed to go online and look for work for many years because of the pandemic. So the effort here is to create something that the look and feel is a lot like Work in Texas, honestly, but it's intended for those that aren't required to provide all of the other information to be able to go in, very quickly register and access the same jobs that are in Work in Texas. We are doing our best, and it's pretty intuitive. We're messaging throughout that new job portal how they can access other services, how they can find a local workforce solutions office if they'd like to find out about some of those other programs that will then require the other information, and even pointing them to Work in Texas for some of the other online learning tools. But the idea is just that they can go either place, but if they're a user that wouldn't be comfortable or understand some of those other federal requirements, then this makes the job more readily available to them. All of the same jobs are in both systems, so no one is missing out by.
But does that make it a little confusing to the client? Doesn't it make it more confusing that we have 2 now? And then the other one is, just to make clarification in my opening remarks, it allows us to be more flexible. Am I right? By using this money. Perfect. That's what I wanted to hear. I just feel like, if we're going to talk about some of these and how we're going to fund them, I'm okay with it. I just felt like we were replicating something that was already in existence, but, you know, it's $180,000, at least not to go over projected cost. I'm okay with it. I mean, if it was brought up by someone and they felt like there was some value in it, I'm okay with it. Just like the other proposals that were brought forth.
Commissioner, very quickly, it is less a replication and more just another entry point that is not as complicated and that doesn't turn off someone because of all, as Courtney pointed out, because of all the information we have to get from someone at the very beginning. And there, we do have customers, and even though we would like to have it skinnied down, we can't because of the federal requirements. We have customers that'll start and go, this is too much. All I want to do is see what jobs are. So we created this other kind of cleaner version of Work in Texas. Same, we're using the same company that's running Work in Texas, ran this very quickly. And it provides less a duplication and more another entry point for people that just kind of want to, they're used to Indeed or Burning Glass or something else without all the federal data. And if we can ever get away from the requirement of all the federal data, then we could have just a single system. We haven't figured out how to do that yet. So this lets us help the most people as quickly as possible. Just find that next career, as you point out, or the next job until they get to that next career.
It occurs to me, Commissioner, based on what Ed just said, because I'm concerned about a similar thing as you are in terms of duplication of effort. Obviously, that's something we should be mindful of. But it does occur to me in today's discussion that Work in Texas might very well be our most valuable tool for unemployment insurance benefit recipients and their work requirements. It might be useful for us to meet WIOA and perhaps TANF and other kinds of requirements that we have on how monies can be used to help people who qualify for certain things or another. But I think something that I heard a lot of concerns about back March, April, May timeframe was that there were open jobs and we not necessarily as a state agency, we didn't have an expedited way to communicate. So many boards pioneered a thing called Jobs Now. And I thought that worked well. If this is an attempt to duplicate that effort so that we're not fulfilling some federal program, but we're simply just exchanging job information between employers and potential employees, I could see that if this pilot program is successful, that it would teach us ways to communicate the difference between the two. I had some similar concerns as you, as today's conversation has really solidified for me that for all these things that we're considering a pilot program, we really need to use this to answer questions and use it for ways to find new ways for TWC to serve the Texans that are the 14 million Texans that are in the Texas workforce and the folks that are still in school and will one day be part of the workforce. So, I can see your point, and I think it's a valid point. But I think in the spirit of pilot programs, this is how we're going to learn to do some messaging. So it's going to be more than just Courtney's division. Perhaps it's going to be more than Mary's division. This is going to be a communications effort for the folks that work with Tom and others. I think it expands beyond today, and I really, we don't push out there often enough, and so Ikea's generosity is giving us an opportunity to do just that, and so that's a valid point. But I think it's one in the spirit of pilot programs. Let's push on that and let's see what we get, because we may find something even better than that, right? And then we can come back and talk about that as a commission.
Chairman, that's exactly the way I approached all of these initiatives that were brought forth as either pilot programs or one-time things. That's exactly what the way I understood this. So I totally agree with what your statement was right now. Something may work, something may not work. And so if it does, all good, prove me wrong. But, I appreciate that. And if it complements our work in Texas, as Consumables would be to Jet, I agree with it. One-time infusion,
Chairman, Item number 6, Texas Careers Job Matching Portal is something that I've stated early on, and I'll continue to state. If it's job seekers and employers is matching in that aspect, that 600,000 jobs, whatever that's out there, those jobs that we have available in Texas, my hope is that this will allow us to quickly match some of those so that those numbers are going down, that we are actually putting people into those jobs, and we're not constantly seeing all the jobs made available in Texas where you have Texans saying, I can't find a job. We want to make sure that we match that as best as possible. And when I heard about the job matching portal, it was with that in mind is the reason that we're coming up with this particular item. And so that's why I've been supportive
Well, as
of it.
referenced earlier, we already have something like that, the jobs now that boards do. So again, I just don't want to cause any confusion. I don't want to duplicate when we talk about using taxpayer dollars. I don't want to duplicate something that we already have in place. I don't want to have to answer, why wasn't this implemented the first time when you all rolled out work in Texas? So, but again, because it's a one-time expense or as a pilot program, and if it works, I'm okay with it. I'm okay with it. But again, I'm just talking to boards. Indeed doesn't have 2 websites. You know, there's no reason to think there's going to be some confusion. But as we referenced earlier on pre-apprenticeship, if it's going to lead to jobs, what I'm going to ask staff is to report to my office how many people will be using my Texas Career Job Matching Portal. If there's a way to see how many people actually use that or work in Texas.
Commissioner,
And
could I expand on that idea and just ask staff off the rip here to just tell us the metrics that they're going to use for each of these in the appropriate style of commission office briefing, and so that we get an understanding of those. I don't see a need for us to intrude on staff's work here by holding off on this or us trying to come up with those metrics. These folks that work with us are professionals, and I trust their judgment here. But I would like to know what the metrics are and at least have the ability to perhaps volunteer some additional metrics based on the folks I'm talking to. And I know commissioners that you're in the same situation as I am. We talk with a lot of constituents and a lot of constituent groups. Everybody wants something different out of everything that we do. But I think more importantly, you know, well, Ikea, who made the contribution in the first place, might like to know our successes here. And I think that there is the potential to have a great story for TWC to tell on how we use a very generous contribution to pilot and pioneer some things that made an immediate difference in our programming and how we made some changes to our programming moving forward. So on that vein, if that is appropriate, I just sort of put that out there and just say that be part of this. It's just understood that staff's going to brief us on the metrics, and we'll have a better understanding of that.
we will do that.
I'm okay with that. I think it's a great idea.
I have some specific questions, but frankly, I think in the spirit of what we've done here by classifying things as pilot programs and one-time expenditures, and then this discussion on metrics, that's going to answer my questions moving forward to my satisfaction. And so, in the interest of respecting everybody's time, I would table the rest of my questions. I should reserve the right to ask those of staff at a future point, but I don't think it's going to inform the deliberations of this commission any further by me continuing to ask my list of questions. That being said, I'm not cutting off your debate. If you have additional comments and questions, please do so.
I have a question for Courtney after. Go ahead, Commissioner Demerson. I'm sorry.
No, you start with number 6 and go ahead.
Well, so mine's going to be on, Courtney, my question is to you and Ms. York. Is there a way to measure performance or return on investment for retail survey, retail data analysis, restaurant videos, and helping businesses transition to teleworking workplace? And that's through one of the initiatives that we have here for videos.
Commissioner, based on today's discussion, I mean, we can answer generally, but we'll do some work on the metrics piece and come back to each of you to let you know what we think would be a good measure of value. I know on some of this, we'll be able to Mary may want to speak to the survey, but when we do the analysis, the cell phone analysis, for instance, and share that with businesses, the goal there is to educate them and help them make decisions on their marketing strategies. The idea on a lot of these is information sharing and making sure they have, because they're hard hit by this pandemic and have costs that they didn't anticipate, that we're trying to provide support by way of analytics to help inform them. On the home project, that clearly that funding would go through the local workforce boards, and they would be providing different supports to businesses on stated need. And so we would intend to have the boards report back to us the types of requests they were getting and the costs that had been incurred and how they were providing support there. Actual outcome of that, we need to think through what the metrics can look like on something like the home initiative, but we know we can trace the number of employers who benefited and to what degree, and some of the common issues that were coming up to help us share information and other resources through the coming months.
Courtney, what is a restaurant video? How does that help a business in transitioning to teleworking? Tell me what that means.
Commissioner
I read
Alvarez.
the brief that you gave me. The discussion you have, which again wasn't much of in detail, but tell me what that does and how, and if the boards are already doing it now, because I think some boards do some of this already.
I think
Mary,
I'll
would you
jump
like
in.
to answer? Okay.
Yeah, I think I'll jump in with that. So, Mr. Chairman, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna, Mary York, the Director of the Office of Employer Initiatives. And to your question, Commissioner Alvarez, that the retail and restaurant videos are really designed to help those businesses either ramp up or shift their operations in compliance with health protocols, and then changing consumer behaviors that have resulted as part of the pandemic. So, we see that by doing these things, producing these videos, that we hope the initiative will support employers, help them be successful, help them retain employees by being able to shift their service delivery methods, and hopefully be forward thinking and thinking about, as we come out of the pandemic, how have consumer behaviors changed in ways that restaurants and retailers can continue to address.
Okay. No, the reason I ask is I know that we have some board areas. I referenced it last meeting that Lori Lorea is doing something like this with those folks that have been dislocated as a result of this. Cameron County received an award where they're doing some of this, and Hidalgo County Judge used some of their CARES money to put videos and inform local retailers about this. I like it. Like I said, all these initiatives, there was nothing wrong with trying this out and see if it works. But I just wanted to know exactly, again, people are doing this already. I understand TWC doing it. It's a great way to market our agency, no different than some of the other things that we've rolled out. So those are some of the questions I had. Thank you for that.
If I may, you mentioned a few of those local boards that are doing it, and that's good that they're doing this. This is a statewide approach, and so this will impact both rural and urban areas, and those that had the opportunity or the funding to do those things that those boards are doing. This is statewide in that aspect, and it will serve all of Texas from that standpoint. So,
and these videos, I'm assuming, will be on our website. So
on our website, online, all over the place. We're trying to give the employers the best opportunities to succeed, and those employers are doing that for their employees from that standpoint, and it benefits all of Texas in that respect.
Hey, again, outside the box thinking was, I enjoy what staff brought forth. This is certainly a lot different than what other states did. And so I compliment them. And so a good initiative.
Thank you, Commissioner.
Mr. Chairman, I go on to say that you mentioned a pilot and on one-time aspects, and I agree with your placement of those items in those particular categories. My attempt with Ikea was to be strategic, looking at this from that strategic approach. Initiatives 3, 4, and 5 that are of interest to me dealt with a nod to Ikea. They're both based in the retail space. And I thought that was very important from a retail operation, actually donating these funds to us. And so those were my attempts to do that. And they were one time in nature from that standpoint. And then I think to your point with the metrics, Courtney, wherever we can get those, that's fine. You may not find a lot on the retail survey from that standpoint. That's information, and we need to do that. And then the data, the analytics, as Courtney mentioned, are going to be just paramount of good interest to individuals as we go forward in basically addressing the two industries that were hardest hit, retail and restaurants. From that standpoint, I want to provide value to those areas.
All right. Any additional questions or comments?
None here, Chairman.
None here.
Ms. Arbor and Ms. York have, is this clear as mud, or do you have what you need from us? We'll do a motion here in just a second.
We have what we need. Thank you.
Thank you very, very much for indulging us in our questions. Is there a motion on this item?
Okay, bear with me, Courtney, and see if I do this right, because it's changing everything up from what I originally had. I was just going to agree with what was approved, but I'm going to make some changes here. I move that we approve the proposed pre-apprenticeship, consumables, My Texas Career Job Matching Portal as pilots, retail survey, data, video, and home as one-time expenditures as discussed, and allow staff to make any funding adjustments to address the technical aspects of the initiatives. So it's the three that the chairman asked for to be pilot programs, if I'm correct, and the rest of them to be one-time expenditures.
Chair, so let me make sure I'm clear on this. I believe number one was going to be a pilot. Number two identified as a pilot. Number 3, 4, and 5 identified as one time. Number 6 identified as a pilot, and number 7 identified as one time.
That is my understanding, and that is what Commissioner Alvarez's motion would do.
Okay.
Yes, sir.
All right, with that, I second that motion.
Been moved and seconded. If there's no further discussion, I'll say we're unanimous. We're unanimous. Thank you.
Thank you, commissioners. Thank you. Thank you, Mary.
We're on agenda item 13. So this is discussion, consideration, and possible action on resource utilization for restaurant recovery initiative to target disaster relief efforts and public health emergencies, including those funded with temporary assistance for needy families funds.
Good morning, Chairman Daniels, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, my name is Dawn Cronin with the Workforce Division, and I'm here to present the discussion paper on the Restaurant Recovery Initiative. The discussion paper, which is posted online as a resource for the meeting, provides greater detail and has been briefed to your offices in the recent weeks. Business closures and shelter-in-place orders, combined with health and safety issues related to the COVID-19 pandemic, have impacted the restaurant industry, with many businesses having been forced to close or lay off employees, resulting in record-setting unemployment claims. Required limitations on occupant capacity and changes in both operating hours and modes of operation have made it difficult for restaurants to open safely and stay open. To help aid the state's economic recovery, the Texas Workforce Commission is particularly interested in efforts that provide relief to employers and help get Texans back to work. Many restaurants need assistance in adapting to these difficult times. Industry needs include redesigning restaurants to provide a safe customer experience, investing in new technologies, adapting business operations, and obtaining industry certifications for employees. As Ms. Arbor described in the Ikea online retail video project, the Restaurant Recovery Initiative seeks to assist employers in adapting jobs to remote and contactless operations and other service delivery trends, such as online ordering, curbside delivery, pickup, and e-commerce platforms, as well as enhanced customer service. The Ikea donated funds will be used to develop the videos and webinars to facilitate this effort. Additionally, many restaurant employers and Texas job seekers would benefit from basic instruction and testing for industry-required food handler permits and desired Texas Alcoholic Beverage Commission Safe Serve certificates. Providing instruction and testing for these permits and certifications would minimize expenses for an industry crucial to the Texas economy that was hard hit by the pandemic and resulting shutdowns. Ikea donated funds may be available to cover a portion of their cost of providing the instruction and testing for permits and certifications required in the restaurant industry. Additionally, temporary assistance for needy family, or TANF funds, are available to strengthen and improve opportunities for our nation's workforce, in addition to helping employers hire and retain skilled workers. The use of TANF funds to provide instructions and testing for permits and certifications to workers in the restaurant industry ensures that Texas employers have a work-ready workforce as operations recover and expand. Staff is seeking directions on making TANF funds available in an amount not to exceed $500,000 to create and implement a restaurant recovery initiative. TWC will enter into a contract with a service provider to provide instruction and testing for food handler permits and TABC certifications at no cost to restaurants, employees, and those seeking a job in the restaurant industry. In an effort to best leverage all available funding resources and to preserve TANF funds, staff also seeks latitude to review the available balance of funds donated by the Ikea Foundation and to brief commission offices on recommendations to partially fund the Restaurant Recovery Initiative with remaining dollars if available. That concludes my remarks for today, and I'm happy to answer any questions you might have.
Any comments or questions?
I'll let Aaron talk first.
Well, I was going to say, Commissioner Alvarez, if you would.
Yes.
Be so kind. Commissioner Demerson, as I recall, requested this from the dais, and staff is responding to his request. I think we'll give him the honors here, and then perhaps you and I might have some questions, if that's okay with you.
Good. Thank you, Mr. Chairman and Commissioner Alvarez, and Don, thank you for the discussion. And Ed, thank you to the team for for working on this initiative. You know, our office has been working with the Texas Restaurant Association, a number of business employers that are out there in this industry. If you look at the numbers, it's the one that is highest hit in regards to this pandemic, and they've been an up and down cycle with that. And something that I've learned over the years with these employers, in particular, how much they care about their employees in that regard, and wanting to keep them on board, but can't do that, and having to turn staff away. Some of the restaurants have had employees for 15, 20, 30 years that have been on their team, family members that have come on to work within those operations as well. And so having to let them go has been pretty hard. And so in opportunity or a way to assist that industry, we wanted to put this initiative forward. The restaurant and food service industry, they've been devastated by COVID-19. Prior to the pandemic, the industry was the second largest private sector employer in the state, consisting of roughly 50,000 locations, 1.3 million employees, and 70 billion in annual revenue to power our economy. Also representing 51% of the Texas food dollar chain, providing for our state's food supply chain in a big way. But by April 30th, 2020, COVID-19 had just pummeled that industry in big ways, resulting in about 750,000 layoffs across the state. And now an estimated 15% of the Texas restaurants have closed for good, leaving close to 200,000 Texans without a job. And so this is a way for us to assist in that area, doing what we can to put those folks back to work, and coupling that with some of the initiatives that have been done, even through our Skills Development Fund program. And I know the support that's out there in regards to doing whatever we can to help our industry. And so the work that's been done at the local level, work that's been done at the federal level, coupled and leveraged with what we can do at the state level, goes over very well for this industry. And Chairman, as you mentioned, hopefully a little bit down the line, we won't be in this situation or in this position, in this one-time aspect of these funds to help in that area will allow us to move forward. And we'll look back at it sometimes and be grateful and thankful for what we've done at the state level to push this forward. So thank you for the opportunity to make some opening comments. And Don, again, thank you for presenting the discussion paper.
You're welcome.
Right. This would be appropriate time for other questions or comments.
Chairman, I hope that the this industry that Commissioner Demerson has identified bounces back from the challenging times that we're facing. And so I agree with the numbers. In some cases, or I think might even be slightly higher than stated. And so I certainly understand the value of this initiative rolling forward. So it's my understanding, Dawn, this is the first time, Ms. Cronin, that I've had an opportunity to talk to you. And so it's my understanding that we have $1 million left in TANF. Is that correct?
That's correct. In the TANF Reserve Fund, $1 million.
So I'm going to ask the commissioners just to give this some thought. And so earlier in item 12, we discussed that we have $423,000 left in, as a result of the Ikea money. And because this is, I would assume would be kind of like a one-time initiative as well, or a program, I asked, I'd be open for some discussion on this, but since the TANF money that we have, we're not even half the fiscal year, and we do not know if we're even going to use this TANF funding to meet any unforeseen circumstances. I am not comfortable with using half of the remaining TANF statewide balance, which is the $500,000 for this initiative, when we're not even halfway through the fiscal year. And so my question to the commissioners is, and to Courtney and Ms. Cronin, would there be an opportunity for us to use the remaining balance of the Ikea in the amount of $423,000 plus change, $629 to fund this initiative?
Yes, sir. We believe, and we're asking for the latitude to look at the available Ikea dollars, barring any unforeseen technical adjustments necessary to the proposed Ikea projects, where costs may come in higher than initially anticipated, would like the flexibility to apply available Ikea donated dollars to this project.
So I know that as stated in agenda item 12, that this gives us a latitude and some flexibility on how Commissioner Demerson and the commissioners would roll out this initiative. I would be open to using the money of 423 plus change to fund this program. And I don't want really at this time to touch into the TANF funding, because again, we're not even halfway through the year, and there may be something that may come up that that the commissioners may want to use the money for, or staff may see appropriate. But because there's so many restrictions to it, I just thought it would be a better opportunity, because of the limitations that Ikea money has, that we could use. This would allow us some flexibility on what we could do and could not do with the money. More could.
What's the price tag on this initiative? It's not to exceed 500,000 on TANF. What was your anticipation on unexpended Ikea dollars? Like outside costs, what are we looking at here?
Are you asking what the anticipated balance of Ikea is? Or are you asking what the anticipated cost of this initiative would be?
I'm asking what the anticipated cost of this initiative is.
We've asked for a budget of not to exceed 500,000. The cost of the permits are rather low, and we anticipate being able to serve thousands of Texans that need these permits and certifications to maintain employment or enter employment. And without knowing exactly, it's going to be depending on how many people actually take advantage of this opportunity.
And if I might just, Commissioners, Courtney Arbor, Workforce Division, if I just might add one comment there. The IKEA, in the IKEA paper that you all just considered, or those initiatives, the videos were intended, it's just a little over $200,000 set aside for the videos, and that would be focused on both restaurant and retail. So there's a number of different outputs with those dollars. I'd say probably about half of that also is part of this initiative. And what the ask would be, and Commissioner Alvarez, I believe that we're in alignment with what we were requesting in the paper, is that after all those IKEA initiatives are said and done, that any dollars remaining would be used would be leveraged here to keep the TANF balance as high as possible.
Commissioner Demerson, on this one, number 2 has, as Courtney referenced, we do have videos and surveys and all of that are in the IKEA already funded. So that's the reason that I was asking if we could lower the amount to the 400, use all the 420,000 to pay for the initiative of moving the amount from 500,000 to 423,000 because some of the things would be duplicated.
Mr. Chairman, go ahead.
Commissioner Demerson, does it matter to you the source of funds, or maybe press Ms. Arthur, was it necessary to use TANF funds? Were we accomplishing something by using TANF funds?
The options were the WIOA or TANF dollars with any remaining IKEA dollars. TANF is the least intrusive as far as documentation and reporting of the federal options we have. And if I just could add, Chairman, the concern I would have about nailing down a dollar amount for this is that if those technical costs of the videos or any of the other more technical aspects of IKEA come in higher, you all approve that we use some latitude in using a little more than planned to cover those. So that 423 is as known today, Commissioner Alvarez, but it could go up slightly as we really dig into these projects.
So Courtney, when you say it could go up, that means the 423 could actually be lower.
That's correct.
Yeah.
That's correct. The cost could go up. So that 423 number I gave you is based on our best estimates now and the fact finding we've done.
Yeah, I think along the lines of Commissioner Alvarez's request, the IKEA dollars, you have a lot more latitude probably to do some things there. What I don't want to do is to jeopardize the 423, the 500,000 up to 500,000 in this request. And so whatever the combination thereof is, I'm fine with that. I just don't want to go down to 400,000 or 300,000 because we've expended a lot more money based on higher costs associated with the IKEA project. And so whatever gets us to the up to 500,000, I'm fine with that. And if that's 100,000, 200,000 out of TANF or so, because of what's happened on the IKEA side, then that's one thing. If the costs are lower on the IKEA side, which means you have more than 423, then you can utilize that as well. But I think we've given in the motion staff the latitude probably to the flexibility rather to do some things there. And so I don't have a dog in the fight on which one. My fight is that I want to do this for, I'd like us to do this for this industry.
Here's my take on it. I actually share Commissioner Alvarez's concern in terms of spending up our last little bit of TANF dollars with more recovery efforts to go. But I support this initiative. My idea would be, we need to vote on this, but my idea would be that we put this into the IKEA list. It becomes an 8th item. It's funded at the level we believe it's funded at. All other items are reduced proportionally to accommodate this item. All 8 items receive funding consideration accordingly. That's how I would do it. Perhaps you have another way, and that's worthy of consideration as well. But I'm strongly enough about the initiative and why we need to do it. Let me tell you something. These restaurant jobs aren't just career jobs for people. They are that. This is the jobs these are the jobs that so many people use to attend community college or attend a 4-year university while they get their degree. These entry-level hospitality sector jobs are absolutely critical to the state's economy. It's what fuels community college enrollment. It's what fuels communities. It's what helps families put food on their own tables. And so an effort to help this sector of the economy recover is definitely something that TWC should pursue. And I'll tell you, I'm double stoked about it because we've got an opportunity here to do something that's a little outside the norm on the way we normally handle things. We're pressing the edges of the box a little bit. This is an industry organized effort that we've been able to participate in. This does so many things for this agency that we've all wanted to do for some time. And this is exemplified here in this particular initiative. So concern on the TANF funds and our ability to use those funds to provide other relief efforts is strong equally. But I'm so confident in this particular initiative, I would be very willing to see reductions made in the other 7 initiatives on the IKEA list to accommodate this one. That would leave a zero balance, but you don't need to worry about that balance anymore because all the initiatives will be in one pot.
Mr. Chairman,
I may add, Commissioner Demerson, it's actually going to be more than $423,000. So your initiative the money that we have left over is 423,000 and change. If you go back to agenda item 12, which was the Ikea, online retail and restaurant videos for urban and rural businesses, contracts not to exceed 210. So 623 and 210 is 600 and whatever. So actually it'll be more.
So I appreciate those comments. I appreciate those comments. Chair Daniel, your suggestion is the one that I appreciate even more. And along those lines, I'd love to entertain the initiative along those lines where we place everything under the Ikea umbrella and reduce down at the others so that we can come up to that up to 500,000 for this particular initiative.
That's good. I agree as well.
Okay, so any further comments or questions?
None here, Chairman.
Commissioner Demerson?
Yeah, I'm gonna have to move this around because we've changed the source of funding in that sentence. So I move to approve up to 500,000. What?
Could I ask you to pause just a second? Sure. This motion that I think is a good motion, Ms. Arbor. Does this in any way place an undue challenge on you in terms of this project or the other projects on the IKEA?
If I understand the motion correctly, that we'll take a proportionate amount off of other to fund this. Whatever the motion is, I believe we'll be able to accommodate it.
Thank you, Ms. Arbor. Commissioner Demerson, I apologize for the interruption.
No, it's okay. I'm gonna try to get through this. I move that we approve up to $500,000 from the foundation dollars for this restaurant recovery initiative, up to $500,000. And I'm moving this around in a sense. We're actually utilizing the TANF at one point, but we're moving from TANF dollars to IKEA. And so the motion is basically to approve up to $500,000 under the IKEA Foundation program to support this restaurant recovery initiative with those dollars. Commissioner Alvarez, are you?
I agree with what you're saying. I'm a little concerned with the motion. Let me ask you how this sounds. Because I wrote down what you had. So I move that we approve the proposal, but direct staff to include this proposal in the IKEA proposals and maximize those funding dollars.
Yeah, up to 500.
Which would be all 423, and then whatever's left over, like I said, there is no money left over. It's 423 because you already have the videos in there because of the IKEA. Remember the 210,000.
Yeah, Courtney, I want to make sure, Don, that we're clear on that in regards to what we're initiating.
So I'm hearing two things, and I would just add that on the technical aspects of the IKEA project, it may be more difficult to just reduce by proportionate share. I'm not as familiar because I haven't been working on those, commissioners. So we can make an attempt, and staff could go back and take a look and see if we could take a proportionate share off to just fully utilize the IKEA dollars by including the full 500 for the restaurant initiative as proposed today, and then reducing some of the others. If we find that there are issues with the more technical pieces of that, it might be that the RFAs are reduced to a slightly greater degree. If you all would like to stay within the IKEA amount to do this, then we could bring some options after analyzing that. Otherwise, I think Commissioner Alvarez, what you're saying is use the rest of the IKEA dollars and then just dip into the TANF dollars to the degree necessary, or are we?
No. My thing is, again, Courtney, agenda item 12 had 210,000 for videos. And so in this particular initiative that Commissioner Demerson wants includes videos. So we're already doing it. So I would say to maximize or utilize the remaining balance of IKEA, which is the 423,000, because of the 210,000 that already has the IKEA, the IKEA and agenda item 12. So it comes out to pretty close to, if not exceeding the 500,000, very close to it. It's 423, and the the videos were 180,000, so it exceeds the 500,000 because the videos are placed in both agenda items, agenda item 12 and agenda item 13. But since we're moving the Ikea funding to fund agenda item 13, you understand?
So what's happening here is basically you're about $77,000 short. And so the chairman's suggestion was basically, let's go up to 500,000, moving that into the Ikea Foundation funds, and then reducing in other areas about $77,000. And so that may be X amount of dollars off of pre-apprentice, X amount off of consumables, X amount off of home, X amount off of the portal, whatever that 77,000 divided by maybe the other 4, 5, or 6 other items or so, that allows for the funding of the restaurant initiative up to $500,000, and the videos and the like are separate. That's my understanding. That's where I'm trying to get.
Commissioner, I don't know where you get the 77,000 short. This initiative, the money that we have that we have left over for Ikea is 423,000. The money that's going to be placed specifically in videos that was referenced in Ikea that you're asking for in this particular agenda item is 210. So total that is $633,000. We've exceeded it by 133,000. We've exceeded what you're wanting.
Commissioner, may I chime in and add some additional detail? This is Mary York from the Office of Employer Initiatives. I did want to point out the video item that was in the Ikea package was restaurant and retail. So that video cost would be shared between those two sectors. And also pointing out that any costs that have been briefed to the offices so far are really estimates at this point, because we really felt like it would be premature to begin to work with a vendor to scope this out until the commission actually reviewed the agenda items and approved those for us to move forward with. So I do want to make sure that you understand, or that the entire commission understands, that some of these numbers in here are estimates. And as Courtney indicated, once we work out the more technical aspects, those dollar figures could change. However, as Courtney indicated, I think, whatever y'all's action is today, we will work within those amounts and produce something that the agency can be proud of.
Yeah, and so I go back, thank you, Mary, for that information. I think I go back to Chairman's suggestion in regards to up to $500,000. The videos, as Mary suggested, that's retail and restaurant, but up to $500,000, and we ratchet down the other areas at that $77,000 or so between those other programs, so that we approach this initiative with that up to $500,000 and not have it at $423,000.
And commissioners, if I wasn't clear, the not to exceed $500,000 amount in the discussion paper for the Restaurant Recovery Initiative is for the sole purpose of the instruction and permitting. The videos that I've referenced earlier in the discussion paper are included in the Ikea project that Courtney laid out earlier. So I apologize if that's confusing.
That's the way I understand it. It's separate. So,
Commissioner, I believe that, may I jump in? I believe that it is around 77,000 that would need to be, we could reduce the other initiatives proportionately to come to that number to fund the restaurant recovery.
right. That's what I'm interested in doing. I think that was the chairman's suggestion as well.
That's correct.
Yeah. All right, Mr. Chairman, so do we need a new motion on this or another motion, or do we have the motion?
Let me hear that motion by.
So basically, I'm moving that we approve up to 500,000 from the Ikea Foundation source of funding, and reduce the other items accordingly to reach that $500,000.
I think that captures the essence of what we were talking about.
Commissioner Demerson, would you be okay with using 77,000 from TANF funding then, instead of touching what we've done for Ikea? We put so much work in it already. I mean, to take a little bit here and there, could we just take the 77,000 from TANF?
Like I initiated up front that, the source, I don't mind. Basically, the not touching the TANF dollars were a result of your comments and the chairman's.
Yeah, I agree.
Here's my take on this. We're just reversing the source of funds rather than supplementing anything that exceeded TANF, the 500,000 from TANF with Ikea funds. All we're doing is dedicating 500,000, or let's say 400,000, and we'll supplement what else is needed with TANF funds. Let's put the not to exceed on the TANF funds and try to make it work out of Ikea funds. I don't want to wipe down the TANF balance to something where we can't tackle a big problem, 2 months from now, because we only have $400,000 left in there. I want to see as much TANF dollars. I'm okay with a proportionate reduction through the Ikea funds, but if Commissioner Alvarez has interest in using some small portion of TANF funds to backstop something, I objection to that as either. I mean, we're talking about a small amount of funds, which still leaves a balance healthy enough to do some real work with if something should come up and we need to do that.
Yeah, so I think if we go 100,000 TANF or so, then and not to exceed 100,000 out of TANF, then we're where we need to go.
And if we do that, that obviates the need for us to do a proportional reduction from the Ikea funds.
Okay, so for the record, I'm okay with that, Commissioner Demerson. And as long as we don't touch anything that we've agreed on the IKEA proposals. So
Yeah, I think
423 of IKEA, that's the balance left over, and TANF not to exceed over 100,000, I would be okay with that.
Well,
Okay.
now, to be fair, Commissioner, this commission made no decisions as to dollar amounts in the IKEA expenditures, just for the record. I think based on information Ms. York just provided, we may see some changes to that as well, but it won't be related necessarily to this restaurant project.
Okay.
It's good clarity, Chairman.
Commissioner Demerson, you are going to need to restate your motion. The intent's there, and I feel confident Mr. Trotman could draw what he needs to draw from this commission hearing. But I think Mr. Trotman and me personally would appreciate it if you would articulate your motion.
Let me try to articulate this motion here. So I move that we approve up to 500,000. Let me restate this because I get this. I approve that we move up to 423,000 from IKEA Foundation funding, supplement an additional up to not to exceed 100,000 from TANF funding for the Restaurant Recovery Initiative.
All right, if Mr. Trotman nods his head along with me, I think that satisfied what we all three just agreed to.
I think it does. And just to be clear, up to the 423 will allow staff to continue to make adjustments as necessary. Basically,
Okay.
voted on.
That's a good.
And I would
check.
agree to that. I would agree to that.
All right. Commissioner Alvarez, your agreement, is that a second, or do you want me to second it?
You can second it, sir.
Second it. Let's go ahead and vote. I'm going to vote in order. I vote aye.
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 All right. It's unanimous.
Congratulations.
Thank you very much, gentlemen.
Thank you, gentlemen, for your support.
Thank you for your time. All right. Mr. Cerna, where are we on the agenda? Are we picking up agenda item 14 now?
Yes, sir, I think we are.
This is agenda item 14, discussion, consideration, and possible action regarding submission of the Adult Education and Literacy AEL Advisory Committee Annual Report.
Good morning, almost afternoon, but not quite. So good morning, Chair Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, my name is Mahalia Baldini with Adult Education and Literacy. TWC Adult Education and Literacy Rule 805.43 requires the AEL Advisory Committee to submit an annual written report to the Commission. Here to present and answer any questions on the Annual Advisory Committee report with recommendations for the Commission's consideration are the newly elected Presiding Officer Donald Tracy with Austin Community College and Mary Jo Ochoa Hernandez the former presiding officer and member who served 2 terms as the committee member. I'll turn it over to Don and Mary Jo at this time.
Paso. So hi, Chairman Daniel and Commissioner Demerson and Commissioner Alvarez. Before Don continues with the summary, I just wanted to give some closing remarks. This will be my last meeting. And of course, like Mahalia mentioned, I have served on this committee for 2 years, and I'm very grateful for your all's opportunity to represent not just El Paso, but the individuals who serve adult students through AEL, the TWC funded program. So thank you very much for, again, allowing me to see this other side of AEL, especially being a representative on this committee where there's so many different types of agencies. And as you all were discussing in the previous 2 agenda items, I think the opportunity and the underlying theme of the report that Don will summarize is integration. And I think that over here in El Paso, we integrate with other agencies because we're the only consortium serving adult education and funded through you all. So that's what I would recommend that you all continue with in any initiatives, especially that have to do with serving adult students, and whether they're funded by AEL or not, open it up to as many individuals as you can so that we can all use our expertise and be able to serve this population and of course Texas and make it as efficient as possible. We've always been an example for the nation and we continue to strive for that. And so again, before Don continues with his presentation, thank you so much for allowing me to speak right now and also be a representative for these last 4 years. Thank you, and may you all have a very Merry Christmas. And that's it. Thank you so much.
Let me interrupt the proceedings. Mary Jo, thank you so much for your service, and Merry Christmas to you too. Without volunteers like you, we don't get everything done that we need to get done. And I know there'll be a chance for all of us at the end to say thank you. But since you were so kind and gracious with your time for all these years, I just want to make a special point of saying thank you to you. And I see some of my fellow commissioners nodding. Perhaps they would like to say something as well.
Yes, Mary Jo, Socorro ISD, #1, huh?
Yes, sir. Thank you so much.
And thank you for what you did. And there wasn't one time when I didn't see a smile on Mary Jo's face. So hopefully that will filter over to Donald Tracy. So thank you for everything.
Thank you, sir.
Mr. Chairman, we have Mary Jo and Donald Tracy. Let me see.
Big difference.
I know them both, but Mary Jo, thank you for all your work. And as Commissioner Alvarez says, that smile is just lights up the room, and we appreciate the passion that you brought to the team and pushing forward. And so it's not goodbye. We'll see you around the corner. So thank you for all that you've done.
Thank you. Socorro ISD, I'm sorry to interrupt, Chairman Daniel. Socorro ISD is an AEL provider, so we continue to strive for #1 and also to continue serving Texas Workforce Commission in Texas. So thank you so much.
Well, thank you. And we have other volunteer opportunities available. I'll share those with you all.
Be happy to. Thank you so much. We need representation from the Far West area. So because we're a unique community. So sure, anything that you all need.
Agreed. All right, back to the program. Where are we?
Thank you. Go ahead, Don.
Well, thank you, Mary Jo. I appreciate your comments. And commissioners, I appreciate the opportunity to visit with you today and give you a little bit of an overview of our committee report and recommendations that we put together for you for this year. I don't have my video, so you'll have to miss my smiling face, I guess, for a few minutes while I go through this report. Obviously this year has been a real challenge for everyone. And of course, those of us on the committee experienced that as well. We have members of our committee who come from all across the state. And so we had to pivot a bit because of the COVID crisis that we've all been experiencing over the last 10 months. And, what we ended up doing was 2 different virtual meetings where we tried to bring together voices from our employer partners, from workforce development partners, and also from adult ed and literacy providers from around the state. what we wanted to do is carry forward some of the recommendations from our 2019 committee report around developing a statewide brand for promoting adult ed and literacy and engaging employers through the integration of AEL services into workforce development opportunities, such as internships, apprenticeships, and literacy programs. And we also wanted to look at some of the services that have been delivered through programming to special populations and those programs that incorporated AEL resources. And so, as I said, those meetings that we held, one in the summer, one in the fall, enabled us to bring employer, workforce development, and adult ed and literacy provider points of view to the table. And sort of an overarching recommendation that we continue to have is that the commission continue to work and promote adult ed and literacy services as an integral part of our economic development efforts here in the state, and particularly looking at how AEL programs can be integrated with other TWC programs and support education and employment goals statewide. So given those efforts and those meetings, in looking at establishing a statewide brand to promote adult ed and literacy, this committee recommends continuing to promote and market adult ed and literacy efforts in order to increase public awareness of the opportunities afforded by these kinds of programs. I think it's important to note that during the last 10 months or so, we've all had to learn new ways of reaching out and connecting with people, and I think that's an important piece of this puzzle as well. I think there's a lot of good learning that has happened across the state, and we'll talk about this in just a minute, but I also think that generates an opportunity to look at best practices on how to reach the populations we serve through adult ed and literacy programming, and to share those best practices. A second recommendation that we have is around engaging employers for workforce development opportunities. And we continue to recommend that we establish and support collaborative projects with adult ed and literacy programming that lead to employment through hands-on training. I think that's a critical component, hands-on training and maintaining a ready supply of skilled workers for our industry partners, whether in the retail or restaurant sector, or advanced manufacturing, IT, other sectors of the economy that are important. And we also suggest that there's some further support that's needed to engage employers around pre-employment skill development, including employability skills or soft skills. That's going to be a really important piece. And finding ways to offer state-funded apprenticeship programs through employer-sponsored partnerships will be an important piece of that. A third recommendation that we have is around enhancing service delivery to the special populations in Texas. We heard from a couple of different groups in our meetings around sort of taught us the importance of multi-agency collaboration if we're going to be reaching out to some of these special populations, let's say those with justice involvement, incarcerated individuals, or those that are recently released. It's important, and this is a theme that I want to really emphasize, it's important that a team, a multi-agency approach be developed for supporting these individuals. We also heard from it was Dollar General who had talked to us about internationally trained professionals and the importance that AEL can provide in helping to build a bridge to good, solid employment opportunity for those internationally trained professionals. And so our recommendation for 2020 is that the agency continue to support coordination across agencies and elimination of duplication of services and braiding funding together in order to help support these special populations. So those are the big three recommendations that we have around promoting a statewide brand for adult ed and literacy, engaging employers more closely in some of the projects and services that are provided through with adult ed and literacy programming, and then looking for ways to enhance service delivery to special populations. In addition to those three big recommendations that we had, we've added a couple of more to the list. And this is where I want to carry forward the team concept. It is critically important that in our locations, our localities, that we engage with faith-based and community-based and nonprofit organizations to build a network of service support for individuals, particularly those that we serve through our adult ed and literacy programs. And so looking for best practices around how those partnerships are built at the local level, I think is going to be a really important piece. And the second component, what we've learned over the last 10 months is how broad, how wide the digital divide really is. It's more of a digital canyon. And so looking for best practices that have happened across the state in our adult ed and literacy system, and connecting with individuals and helping to enhance digital literacy skills so that individuals are able to not only access services, but access education and training opportunity that helps them grow. That's going to be an important piece. So in addition to our big three, we've got two more recommendations around building local teams with community-based, faith-based, and nonprofit organizations, and increasing digital awareness. And so that sort of sums up our report for this year. And I'd like to turn it back over to you all if you have any questions or suggestions on it.
Any comments or questions for Mr. Tracy?
Thank you, Don, for being appointed to as chairman of the AEO Advisory Committee, and we look forward to working with you. And thanks for all you do.
Yes, sir. Thank you.
And Don, I like that second bullet where you engage in employers. I look forward to, as I've mentioned to my working with you guys in any way that I can as relates to what your outreach efforts will be for employers here in our state.
Thank you.
Okay. Any additional questions or comments? Ms. Baldini?
No, sir.
Ms. Baldini, I know Ms. Ochoa Hernandez is leaving her role as presiding officer. Are there any other members parting the department?
We do. We have one other member that will be departing, and we've already had our last meeting of this calendar year, and that is Tiffany Johnson from Victoria College.
And so same shout out to Ms. Johnson for her service. As Ms. Ochoa Hernandez, it's hard work and it's all volunteer. Can't tell you how much we appreciate everything you guys are doing.
Absolutely. Second.
Thank you so much for a very comprehensive report. We really appreciate it very much. Great things coming out of AEL. Our staff's pretty energized. I know the commissioners individually and collectively as a group, we're trying to squeeze every little bit out of AEL. It's such a critical program. We want to help as many people as possible, and we'll continue down that path. All right. Anything else for Mary Jo or Don or Mahalia? Guys, thank you so much for your time today.
You're welcome. Thank you.
Thank you. You have a great day.
Yep.
This will bring us to agenda item 15, discussion, consideration, and possible action regarding submission of report to the Texas Workforce Investment Council, the governor, the Legislative Budget Board, and progress of the AEL strategic plan.
Good afternoon. Again, it's me. Good afternoon, Chair Daniel, Commissioners, and Mr. Serna. For the record, again, Mahalia Baldini with Adult Education and Literacy. In the Adult Education and Literacy Strategic Plan for fiscal year 2015 to 2020, the Commission outlined a 5-year vision for the AEL program in Texas, creating 4 strategies that would support adult education and literacy meeting its milestone of serving 20,000 students in career pathways by the year 2020. The General Appropriations Act, specifically Rider 30 of the 86th legislative session, requires AEL to report on the progress of these goals and strategies, which are to increase workforce secondary and post-secondary education and training outcomes, address demand, increase system coordination and integration, and to improve performance excellence. To date, the Adult Education and Literacy has served over 35,000 students in career pathways, surpassing this milestone. This report also outlines how Texas AEL has continued to support these 4 strategies in serving workforce customers. At this time, staff seeks direction on the submission of the 2020 Adult Education and Literacy Strategic Plan Progress Report to the Texas Workforce Investment Council, the governor, and the Legislative Budget Board. Thank you so much for your time this morning, and I'm happy to answer any questions.
Any comments or questions?
No, Mahalia, great report. And I'm glad to see that we're working with Wyndham School and those individuals that have been incarcerated with Don Tracy. So thank you for that.
Absolutely.
Mr. Chairman, Commissioner Alvarez, I'd like to, and Ed, thank you guys for addressing the legislative issues that were brought up a session ago. I think that's been incorporated into this new report, and we appreciate that.
Absolutely.
All right. Thank you very much. Is there a motion on this issue?
Yes, sir. I move that we approve strategic plan for audit, education, and literacy progress report presented by staff to be submitted to TWIC, the governor, and the Legislative Budget Board.
Second, the motion.
Moved and seconded. Will you notice?
Thank
Thank
you.
you. Thank you. 16, discussion, consideration, possible action regarding establishment of a late refund penalty rate for career schools and colleges pursuant to Texas Education Code Section 132.061E.
Good afternoon, Chairman Daniel. How's the sound?
Good. You're very good.
Okay, so again, good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Sarna. For the record, Carrie Ballast, Workforce Development Division. Texas Education Code 132.061 requires a career school or college to pay student refunds within a 60-day period. Failure to do so requires the career school or college to pay a penalty. Section 132.061 also requires the Texas Workforce Commission to establish annually a penalty rate at a sufficient level to act as a deterrent to the retention of student refunds. The current 250% rate has proven to be effective in encouraging career schools and colleges to pay student refunds in the required timely manner. So at this time, staff seeks direction on the establishment of the late refund penalty rate for calendar year 2021, requesting that it remain at the current annual rate of 250%. That's it. I am happy to answer any questions. Thank you.
Comments or questions?
None here, Chairman.
None.
Do we have a motion on this issue?
I move that we approve the penalty rate for late refunds at the current annual rate of 250%.
Second, the motion.
Been moved and seconded. We're unanimous. Thank you.
Thank you.
I'm informed staff has nothing to report on agenda item 17. On agenda item 18, this is our standing COVID item. Mr. Stern, do we have anything under agenda item 18?
No, sir, we don't have anything to report there.
Thank you. Agenda item 19, discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Good afternoon, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Serna. For the record, Shanta Williams with the Workforce Development Division. And before you for consideration are workforce board nominations for Workforce Solutions Capital Area, North Central Texas, Greater Dallas, and Texoma. Staff recommends that all nominees be approved, and I'm here to answer any questions you may have.
Any comments or questions?
None here, Chairman.
Good. Go.
All right. Do we have a motion on this issue?
Chairman, I move that we approve the board nominees for Capital Area, North Central Texas, Greater Dallas, and Texoma.
Second, the motion.
It's been moved and seconded. We're unanimous.
Chairman, I have a question or a
Yes, sir.
request.
Yes, sir.
Can we take a quick break so we can use the facilities?
That is a reasonable request, Commissioner Alvarez. Let's take a little recess.
Thank you.
Field Operation Handbook and decisions of federal courts regarding the FLSA. This clarification would benefit both employers and employees by simplifying compliance with the law through incorporation of well-known federal standards into the Texas definition of wages, and will help ensure that all federally allowed deductions for pay are legal in Texas as well. The first part of this proposal would add a definition to section 61.001 to clarify that the term state or federal law includes any regulations, rules, administrative interpretations, or formal opinions of the U.S. Department of Labor, the Commission, and decisions of court or of competent jurisdiction regarding relevant provisions of Texas and federal wage and hour laws. The second part of this proposal would amend section 61.0182 of the Labor Code. The current wording is ambiguous since, as a practical matter, authorized to do so under state or federal law has been interpreted as required under the law. But under TWC's enforcement policy, it also includes deductions that are authorized under one specific DOL regulation dealing with deductions from an exempt employee's salary, and deductions authorized by two specific Texas statutes governing administrative fees for handling certain garnishments. However, the same policy does not apply to other deductions specifically authorized under DOL regulations, such as deductions for voluntary wage agreements and union dues, to name just two.
Any questions?
My comments to this one, Chairman. This proposal would provide that interpretations of law and DOL guidance and state or federal court opinions are themselves law under section 61 of the Texas Labor Code. It seems unnecessary and potentially confusing to elevate these interpretations into actual law. Further, it would make it easier for employers to make deductions without written authorization from employees. This could have the consequences of increasing disputes between employer and employee. This proposal does not improve the functioning of the Texas payday law.
My concern is not with the intent, it's the construction of the language. I also think it's a bit permissive. I don't think we should abandon this concept. I would encourage us to take this back to the drawing board and see if we can find a way to write this that kind of moves these concerns about conflating law with regulation and perhaps a court case before we make, sort of ask somebody to make that into a law. So the concept, I'm certainly in favor of trying to find a solution to. Unfortunately, the construction of this proposed legislative language does give me some concerns.
All right, Mr. Chairman, can you hear me?
Let's try, you were cutting in and out. Let's try it again, if you don't mind.
Yeah, so basically, it's just for further clarification of the payday law is what we're seeking. And so I'd move, and if it dies for a lack of a second, we'll understand that, and we'll move forward accordingly.
Commissioners, at this time, I do not support this proposal.
All right, let's take this one back to the drawing board with no second. Let's don't proceed, but let's don't abandon this idea.
Sounds good. Thank you.
Thank you, sir.
Thank you. Next, on page 15 of your packet, we have Commissioner Demerson's proposal related to clarifications that enable improved overpayment recovery. Commissioner Demerson.
What I'm going to do with the improved overpayment recovery, I want to go ahead and pull that one for now and move to our fairness or corrections for reimbursed employers. And so this improved overpayment recovery item, I pull that one down.
Yes, sir. The next we'll move to page 17, which Commissioner Demerson is your proposal related to, as you just mentioned, the correction to reimbursing employers unemployment insurance tax liability.
Good. Thank you, Michael. So under current law, reimbursing employers may be relieved of liability only under two circumstances. Number one, or A, the work separation resulting from a discharge for misconduct connected with the work, or B, the work separation was due to the claimant resigning without good cause connected with the work. Legislative remedy, reimbursing employers will no longer be responsible for paying for benefits from claims that should never have been filed or allowed to proceed in the first place. Many reimbursing employers have been hit with reimbursement liability for benefits paid to claimants who filed fraudulent or questionable claims, even though they were still employed by the reimbursing employer on the same basis as they were prior to the claim. These problems can be addressed with 3 simple changes in section 205.0125 of the Act. Number 1, add a new subsection to clarify the meaning of voluntarily leaving work without good cause connected with the individual's work. That term should be defined as any reasons for leave that is unrelated to the individual's work, notwithstanding any of the exceptions to the disqualification enumerated in sections 207.045 and 207.046. Number 2, add a reimbursement liability exemption category pertaining to benefits paid out for claims if there has been no separation from the reimbursing employer's employment at the time the claim is filed. And lastly, add a reimbursement liability exemption category pertaining to benefits paid out for claims that were ultimately found to be void or disallowed due to the claimant not being unemployed at the time of the filing, or else fraudulently claiming benefits by concealing earnings or employment in order to draw benefits. This change in law would also go very well with both initiatives from Commissioner Alvarez, which I've supported.
Commissioners, because of the additional cost to the trust fund, it's unclear in which situations this provision may apply. And reimbursing employers can elect to be regular chargeback employers and receive all applicable chargeback protections.
Commissioner Alvarez, what's the cost to the trust fund?
So we didn't have an analysis this time, but we had one done last time. And we have it here. Let's see, just looking at the claim. Remember, we didn't have one this time, but the last time we brought this initiative up, the trust fund cost would be $1,327,735 and an administrative cost of $197,000. This doesn't include the other types of separations that this may cost.
So 197,000.
So I'm just looking at it as that perspective because of the trust fund. That's the only reason that I felt this was. It is a good initiative. Get me wrong. Don't get me wrong. That was my concern.
Yeah. And this goes in line with those initiatives that you proposed as well initially. And so trying to find protection for reimbursing employers, that's what we're trying to do with this. So yeah, the reason for bringing it up.
Chairman?
Can we get some clarification on the cost of the trust fund? I'm not finding that in the materials that we were presented here.
So we asked for this at last session and we got the cost analysis, and for some reason we did not get it this time. So that might be why you don't have it in your documents. We're basing it off of what we got last year or last time this was proposed. So I would turn it over to Michael.
Can we table this and so that somebody can tell me what the costs are?
Yes, sir.
Certainly.
All right.
If that's the commissioner's decision.
Yeah, let's table this one and bring it back at the next available commission meeting with some additional information about cost. Any objection?
None here, Chairman.
Hearing no objection. Mr. Britt.
Thank you, commissioners. That concludes my presentation on this item.
All right. I think that clears away agenda item 20. That's correct. Agenda item 21, legislative report.
Good afternoon again, commissioners. Mr. Cerna, for the record, Michael Britt, Governmental Relations. Quick update. As you're aware, last Friday, Congress passed H.R. 8900, the Further Continuing Appropriations Act of 2021 and other extensions. This bill continued federal funding beyond its expiration last Friday until this Friday, December 18th. Congressional leaders are continuing to work on an omnibus spending measure that will fund the federal government for the remainder of this fiscal year. And we will keep your offices informed as developments occur on that legislation. And that concludes my remarks. I'm happy to answer any questions.
Any questions or comments for Mr. Britt?
None here, Chairman.
Fine.
All right, thank you. Mr. Sarna, on the Executive Director's report.
Yes, sir. Two quick things. I know we've been here a long time, but I think these are relatively notable. First off, and both of them are compliments to the TWC staff, because despite everything that they're working on, they still found time to contribute to what I believe are two very worthy causes during the holiday season. The first is Coats for Kids Drive. I would like to note that TWC placed second in the large organization category. I'm sure there's a way that we placed first in some other category, but in that particular category, we placed second. My congratulations to the staff. Keep in mind that a large majority of our staff are remote working. So for us to contribute that level of coats in the buildings meant that staff either came in to donate coats, or the staff that were coming into the office or are coming into the office donated a significant number of coats. So my compliments to the staff. I'd also like to offer a special thanks to Kimberly Watson for her efforts to, first of all, bring this program into TWC last year, and then second, for coordinating the effort again this year here at TWC. So I think that was very notable. The second thing is holiday wishes in partnership with Partners for Children and the Governor's Commission for Women. TWC employees donated Christmas gifts for 99 children that are in foster care, and combined with 33 other state agencies, we provided Christmas gifts, which included clothing and toys for almost 2,700 children. So TWC almost reached 100. I'm not quite sure how we missed it by one. If I'd have known, I'd have picked up one more. But 99 children received gifts, and then again, collectively, the 33 agencies, 2,700 children. In that case, Jennifer Kohlhauer on my staff coordinated our efforts there, and we had people bringing gifts in, again, both people that were working remote as well as in the building. So again, my compliments to the TWC staff for going a little bit extra beyond everything else that they're doing to help people that are less fortunate than us. And that's all I have to report, Mr. Chairman, other than to say to you and Commissioner Demerson and Commissioner Alvarez, I wish you all happy holidays. I appreciate your support. The staff and I appreciate you all's support, and wish that you have a happy holidays, and we will see you next year.
Mr. Cerna, thank you so much. I would love to go on and on with you about Kimberly Watson, but she's sitting 9 feet away from me. I don't want to glare at me for saying too many nice things about her. I am absolutely amazed at the people who put in the hours that we've been putting in up here and still go out with their service organizations and do the things that they do for the community. The unwritten stories sometimes are the best stories, and I guess we're writing this one today right here on Zoom, but the fact of the matter is that Kimberly, Jennifer, and so many others here at TWC, frankly, are models for the rest of us. If you want to see what true leadership looks like, take a look at what some of these folks are doing for our community here in Central Texas, and I think you'll see an example of what real leadership looks like. Mr. Cerna, Merry Christmas to you and happy holidays to all as we move out of here. Commissioners, is there anything else or any other order of business to come before this commission?
Chairman, if I may say something right now, I am truly blessed to be working for this fine institution we all call the Texas Workforce Commission. We do great things, and it's everyone working together. I am so blessed to be working with Commissioner Demerson and yourself, Chairman, and great leaders like Ed Cerna and all his directors and the staff, our call center folks, and everyone at UI. Everyone's done such a great job and great work during this obviously challenging times. So I wanted to wish everybody a Merry Christmas, and again, I'm very blessed to be working for such a fine institution, and I thank the governor for the opportunity to serve at this capacity. I'd also would be remiss if I didn't acknowledge that Margie Franks, after 42 years of state service, has decided to retire, and at the end of the month, she'll be retiring again after 42 years of service. We're gonna miss Margie. We're gonna miss her smile, and we're gonna miss just everything about her. I'd also like to acknowledge her husband, Marcus, and of course her sons, DeMarcus, Desiree, and of course, Danae, for allowing us to share Margie with them. So again, thank you, Chairman, for the great work. I had a great year, even though we had some challenging times. I think we made a huge dent in the economy of Texas, and it's certainly obvious by all the companies that are coming to this great state of ours with the workforce boards and everyone that works for the agency. I commend them for the great work. So thank you for allowing me to express, my appreciation for the agency and for the opportunity to work side by side with my fellow commissioners.
Thank you.
I echo all the comments that have been made, Chairman. Kimberly and Jennifer, the coats and the foster kids giving gifts. What a way to end a year. And it's been a heck of a year. You know, we started out in January, moving fast, in February, March, and the world started changing in big ways. And now we find ourselves in December. And just commend the efforts of Ed and the entire team. A lot of heavy lifting when you look back. And I am delighted to have served in that role with our fellow commissioners, Chairman Daniel and Commissioner Alvarez. Appreciate you guys big time. We've been able to do a lot and move in a lot of ways. And I'm looking forward to what the future is going to hold for us. And so new initiatives, new opportunities, and we're looking forward to what's next. But you guys stay safe and have a Merry Christmas. And we're looking forward to a good new year as we better new year, as Tommy Simmons, our general counsel, says, a better 2021. So
I miss Adam Leonard's chocolates. He forgot to come by and give us some. He used to always do that.
Well, mine were delicious. I'm kidding. He didn't deliver any either. That didn't happen. Gentlemen, thank you so much for the opportunity to work together. So many interesting things going on in 2020. I know 2021 brings a new year. I know we have more work to do for the rest of the week and probably into next week a little bit, but this is our last regularly scheduled commission meeting for the year. And so this commission will not be meeting until 2021. And so Merry Christmas to all and Happy New Year. Adjournment hat. So if there's a motion to adjourn, we can adjourn at this point.
That hat?
I move that we adjourn, Chairman, and I look forward to seeing everybody next year. Oh, I love the hat.
He's just catching on to the hat. So.
I didn't see it, man, with these glasses. These are over-the-counter glasses, man.
Let's not speak about glasses. I second the motion, so.
Been moved and seconded to adjourn, and so we are adjourned. Gentlemen, thank you.
Thank you, Chairman.
Thank you, guys.